Section 1 of TikTok, Collected Reports. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. TikTok, Collected Reports by Various. TikTok, Technology Overview and Issues by Patricia Maloney Figliola. Released June 30th, 2023. Summary. TikTok is a globally popular video-sharing smartphone application, app, owned by ByteDance Limited, a privately held company headquartered in Beijing, China. It is under increasing scrutiny by the U.S. government as a potential privacy and security risk to U.S. citizens. This is because ByteDance, as with all technology companies doing business in China, is subject to Chinese laws that require companies operating in the country to turn over user data when asked by the Chinese government. Researchers differ over how TikTok data collection compares with other social media apps and whether TikTok poses a threat to the privacy and security of its U.S. users. TikTok launched in the United States in August 2018. The app is available in about 150 countries and 75 languages and has approximately 1 billion monthly active users. In the United States, the app has approximately 150 million monthly active users. TikTok's appeal lies heavily in what has been called its addictive video feed, called the For You feed. The app builds this feed through a recommendation engine that uses artificial intelligence, AI, technologies, and data mining practices. According to the company, the recommendation engine relies on a complex set of weighted factors to recommend content, including hashtags and videos watched previously, as well as the kind of user device. TikTok critics cite problems with how much data TikTok collects from and about its users, and with how that data is stored and could be shared. Some critics have also raised concerns about how TikTok promotes certain content to users and the potential to spread misinformation or propaganda. On August 6, 2020, then-President Trump signed an executive order aimed at stopping TikTok from doing business in the United States. If the order had gone into effect on September 27, 2020, as scheduled, it would have prohibited any U.S. company or person from transacting with ByteDance. On August 14, 2020, President Trump issued a second executive order stating that ByteDance must divest from all assets that support TikTok's U.S. operations and destroy all previously collected U.S. user data. Divestiture may be accomplished by finding a U.S. buyer for TikTok. The requirements were designed to limit the Chinese government's access to current and future data from U.S. TikTok users. ByteDance did not want to divest from TikTok and sued the Trump administration. In 2021, President Biden rescinded both executive orders, but his administration is still considering options to curtail TikTok's ability to operate in the United States. On September 14, 2020, Oracle announced that it had reached an agreement with ByteDance to, quote, serve as the company's trusted technology provider, end quote, in the United States. It is unclear whether this deal would have satisfied the conditions in President Trump's now rescinded executive orders. Then Secretary of the Treasury, Steven Mnuchin, said that the Committee on Foreign Investment in the United States, CFIUS, would review the proposal and present President Trump with its opinion. Negotiations between TikTok and the Committee on Foreign Investment in the United States remain ongoing. During the 118th Congress, some members have introduced various bills that would affect TikTok's ability to continue operating in the United States. For example, Representative Michael McCall introduced the Deterring America's Technological Adversaries Data Act, House Bill 1153, on February 24, 2023, which was reported favorably by the House Foreign Affairs Committee on May 16, 2023. House Report 118-63. Representative Kat Kamek introduced the Chinese-owned applications using the Information of Our Nation Caution Act of 2023, House Bill 750, on February 2, 2023. Representative Ken Buck introduced the No TikTok on United States Devices Act, House Bill 503, on January 5, 2023. Senator Josh Hawley introduced the No TikTok on United States Devices Act, Senate Bill 85 on January 25, 2023. Representative Brian Babin introduced the Terminate TikTok on Campus Act of 2023, House Bill 231, on January 10, 2023, and Representative Jack Bergman introduced the Protecting Personal Data from Foreign Adversaries Act, House Bill 57, on January 9, 2023. Additionally, the House Committee on Energy and Commerce held a hearing on TikTok on March 23, 2023, titled TikTok: How Congress Can Safeguard American Data Privacy and Protect Children from Online Harms. Some stakeholders believe TikTok and other Chinese-owned apps pose serious security risks to the United States because Chinese companies are subject to China's laws that require compliance with Chinese government requests for data. Others believe that TikTok has fallen into the crosshairs of a global technology battle based on technology trade protectionism. Similar situations may arise in the future with other apps created by foreign companies. At least 15 countries have partially or completely banned the TikTok app. Options that Congress may consider include 1. Developing an overarching legal and regulatory framework to protect the security and privacy of U.S. citizens' data and communications, and 2. Developing a uniform, transparent process to assess and mediate risks from foreign apps. Background: TikTok is a popular video-sharing smartphone application app owned by ByteDance Limited, a privately held company headquartered in Beijing, China. The app has been under intense U.S. government scrutiny for the past few years as a potential privacy and security risk to U.S. users. A major concern is that ByteDance is subject to Chinese laws that require companies operating in China to turn over user data when asked to by the Chinese national government. Researchers differ over how TikTok's collection of user data compares with other social media apps, and whether TikTok poses a unique threat to the privacy and security of its U.S. users, who include many minors. This report describes the underlying technology and programming of the TikTok app and recommendation engine, as well as how TikTok collects, stores, and shares user data. Additional information about restricting the use of TikTok, including the legal history, current legislative proposals, considerations for Congress, and a discussion of recent data privacy and national security concerns, can be found in the following Congressional Research Service products: Congressional Research Service Legal Sidebar LSB 10940, Restricting TikTok Part 1, Legal History and Background by Stephen P. Mulligan, Congressional Research Service Legal Sidebar LSB 10942, Restricting TikTok Part 2, Legislative Proposals and Considerations for Congress by Stephen P. Mulligan and Valerie C. Brannon, Congressional Research Service Insight IN 12131, TikTok, Recent Data Privacy and National Security Concerns by Kristen E. Bush, and Congressional Research Service Legal Sidebar LSB 10972, Montana's TikTok Ban and Pending Legal Actions by Sanchita Jairam and Madeline W. Donnelly. What is TikTok? On August 2, 2018, U.S. users of the Musical.ly app, a short video service headquartered in Shanghai, China, with a U.S. office in Santa Monica, California, found that their accounts had been merged into TikTok. Musical.ly had been acquired by ByteDance, the owner of TikTok, in November 2017 for $1 billion as a means for ByteDance to enter the U.S. market. The TikTok app is available in about 150 countries in 75 languages and has approximately 1 billion monthly active users. In the United States, TikTok has approximately 150 million monthly active users, and the company maintains offices in Los Angeles and New York. When ByteDance first released the TikTok app in September 2016, videos could be no longer than 15 seconds, but now users are allowed to create videos up to 10 minutes. ByteDance is currently estimated to be worth $220 billion. TikTok's recommendation engine. TikTok's appeal relies on what has been called its addictive video feed, For You. For You is filled with endless curated content selected using TikTok's recommendation algorithm. It is similar to Instagram's Explore page and other recommendation-based app designs. However, while both apps consider the videos that a user has interacted with in the past, the accounts and hashtags they have followed, their location and language preferences, and the content the users themselves create, the apps have different methods to prioritize what users see when they open the app. On Instagram, the main feed contains content shared by the people that users follow. The Explore page is a secondary tab, and to see it, users must click away from their main feed. On TikTok, that is reversed. For You is populated with videos selected by TikTok's algorithm, mostly from creators the user doesn't know. The app builds this feed through a recommendation engine using artificial intelligence, AI, technologies, and data mining practices. How each user's feed is constructed had been a tightly held secret until June 2020, when TikTok published a blog post, How TikTok Recommends Videos, #ForYou. The company says its algorithm relies on a complex set of weighted factors to recommend content based on user preferences, including hashtags and videos watched, videos liked, shared, and commented on, as well as the kind of device a person is using. Each user's feed is unique to the individual. Table 1 lists the specific factors used for recommendations according to TikTok. Table 1. For You, feed factors and elements. Factor, user interactions. Elements, videos liked or shared, accounts followed, comments posted, content created. Factor, video information/details. Elements, captions, sounds, hashtags. Factor, device and account settings. Elements, language preference, country setting, device type. These factors are included to make sure the system is optimized for performance, but they receive lower weight in the recommendation system relative to other data points because users don't actively express these as preferences. According to TikTok, quote, all these factors are processed by our recommendation system and weighted based on their value to a user. A strong indicator of interest, such as whether a user finishes watching a longer video from beginning to end, would receive greater weight than a weak indicator, such as whether the video's viewer and creator are both in the same country. Videos are then ranked to determine the likelihood of a user's interest in a piece of content and delivered to each unique For You feed. End quote. The blog post was seen by stakeholders as an effort to provide more transparency to the public as the U.S. government was increasing its scrutiny of the company's practices. Data collection, storage, and sharing by TikTok. Critics, including some members of Congress, cite as problematic the amount of data that TikTok collects from and about its users, how that data is stored, and how it could be potentially shared with the Chinese government and used in influence campaigns or against U.S. citizens. Because of these concerns, the federal government and more than half of U.S. states have banned the app on devices issued to certain government employees. Some private firms, such as Wells Fargo Incorporated, have banned or discouraged the use of the TikTok app. Data collection. According to its privacy policy, TikTok collects a range of user information, including location data and internet address, keystroke patterns, and the type of device being used to access the app. The app also collects and stores a user's browsing and search history within the app, as well as the content of any messages exchanged using the app. Additional information can be collected based on user permission, phone number, phone book, and social network contacts, GPS data, user age, user-generated content, such as photos and videos, store payment information, and the videos liked, shared, watched all the way through, and rewatched. TikTok continues to state that the app does not collect more user data than other social media apps and online platforms, such as Facebook and Google. Both of these companies track user activity across devices, while TikTok claims that it does not. According to some scholars, the data that TikTok collects from users appears to be comparable to what other social media companies gather and use. However, some critics have described TikTok's approach to data mining as aggressive and argued that its ability to track user behavior while using the app, as well as its access to a user's photos, videos, and phone book and geolocation tracking based on user permissions, means that it can build extremely detailed behavioral profiles of its users that could potentially be shared with the Chinese government. On February 14, 2022, The Wrap reported, quote, TikTok can circumvent security protections on Apple and Google App Stores and uses device tracking that gives TikTok's Beijing-based parent company ByteDance full access to user data, according to the summaries of 2 major studies attained by the RAP that appear to confirm long-standing concerns raised by privacy experts about the popular video-sharing app. End quote. Data storage. TikTok claims to store all content created by U.S. users, as well as data about those users, only on servers located within the United States and in Singapore. Those servers are owned or controlled by TikTok, but the company denies that it shares or would share this data with the Chinese government, stating, quote, "The key personnel responsible for TikTok are all Americans based in the United States, and therefore are not subject to Chinese law. U.S. content moderation is likewise led by a U.S.-based team and operates independently from China, and as noted above, the TikTok application stores U.S. user data on servers located in the United States and Singapore." End quote. Data sharing. TikTok has asserted that all user data is stored in servers located within the United States and Singapore. However, in testimony to the House Committee on Energy and Commerce on March 23, 2023, TikTok's chief executive officer, Shou Zichu, stated that ByteDance may still have access to U.S. data. Further, a lawsuit filed in federal court, footnote. This case was transferred to an Illinois district court as part of a multi-district litigation proceeding, end footnote. In December 2019, asserted that user data was harvested and sent to servers in China. White House TikTok executive orders. Then President Trump issued 2 executive orders affecting the future of TikTok in the United States. One on August 6, 2020, Executive Order 13942, and another on August 14, 2020, no number assigned. In 2021, the Biden administration rescinded Executive Order 13942. It has chosen thus far not to enforce the order of August 14, 2020. For details on the 2 executive orders and legal challenges, see Congressional Research Service Legal Sidebar LSB 10940, Restricting TikTok Part 1 Legal History and Background by Stephen P. Mulligan, and Congressional Research Service Legal Sidebar LSB 10942, Restricting TikTok Part 2 Legislative Proposals and Considerations for Congress by Stephen P. Mulligan and Valerie C. Brannon. China's cybersecurity law and export rules. The cybersecurity law of the People's Republic of China was passed in November 2016 and went into effect in June 2017. It was updated in November 2018 by the Regulations on Internet Security Supervision and Inspection by Public Security Organs, and again in September 2022. The law strictly controls online activities, mandates the local storage of user data and the registration of certain network assets, and allows the government to conduct on-site and remote inspection of computer networks. Footnote. Computer networks are generally defined in the cybersecurity law as 5 or more computers connected to the Internet, a definition that applies to almost every foreign company operating in China. End footnote. The law requires Chinese companies to cooperate with government intelligence operations if so requested, and may allow the Chinese government access to user data collected by any company doing business in China. One analyst notes that, quote, by demanding access to any data collected and stored in China, the updated regulations force domestic and foreign companies based in China to comply with its investigative measures, leaving intellectual property and private information vulnerable to government abuse. End quote. On August 31, 2020, China took specific action that could prohibit the sale of TikTok's underlying technology and processes. The new export regulations cover such technologies as, quote, text analysis, content recommendation, speech modeling, and voice recognition, end quote. Since the recommendation engine is considered one of the key elements of TikTok's success, a ban on transferring the technology and processes used to create it would make it more difficult to sell the app or prevent a sale altogether. Status of potential Oracle partnership with TikTok. On September 14, 2020, Oracle announced that it had reached an agreement with ByteDance to, quote, serve as the company's trusted technology provider, end quote, in the United States. From the terminology used in the proposal, it appeared that the deal involved a partnership rather than a sale, with TikTok using Oracle's cloud hosting services. This arrangement would keep the source code of the For You feed and algorithmic recommendation engine in the hands of ByteDance. As of June 2023, the Committee on Foreign Investment in the United States, CFIUS, which was charged with reviewing the national security implications of the agreement, had not reached a decision regarding TikTok's possible forced divestiture or other requirements. On September 19, 2020, Oracle announced that Walmart would join its bid for TikTok, with the two companies acquiring 20% of a newly formed company, TikTok Global, and the remaining 80% owned by ByteDance. According to announcements made by the companies, 40% of ByteDance is owned by U.S. investors, so that the new company would be under majority U.S. ownership. However, this arrangement, along with TikTok keeping the For You recommendation engine algorithm, would not appear to satisfy the conditions of Executive Order 13942. On September 23, 2020, TikTok filed for and was granted an injunction in federal court to stop the ban on the app that was set to take effect on September 27, 2020. TikTok was granted an extension until November 27, 2020, to persuade the U.S. government to approve the deal with Oracle and Walmart. The extension date passed, but the Biden administration did not enforce the ban that had been set to take effect. Due to the ongoing Committee on Foreign Investment in the United States examination, as well as legislative and executive efforts to ban the app in the United States, in March 2023, TikTok was reported to be reconsidering a partnership with Oracle and Walmart. Discussion. Some believe TikTok and other apps developed and owned by Chinese companies pose a serious security risk to the United States because Chinese companies are governed by China's cybersecurity law. Others believe that TikTok is caught up in increasing trade tensions between China and the United States. Threat to security. Although TikTok forcefully states that it does not share U.S. user data with the Chinese government, many security and privacy advocates are skeptical. TikTok did admit that employees in China had accessed the data of a few U.S. journalists in 2022. That incident is being investigated by the Justice Department. Other countries have acted against TikTok on the grounds of security. India banned TikTok and 50 other Chinese apps in June 2020, calling them a, quote, threat to sovereignty and integrity, end quote. Also, in June 2020, the European Union opened an investigation into TikTok to examine possible violations of its General Data Protection Regulation, GDPR. Australia had threatened to ban the app, but on August 4, 2020, the country's prime minister indicated that TikTok would not be banned. However, in March 2023, 68 federal agencies in that country banned the app on work-related phones. At least 15 other countries have partially or completely banned the app in 2022 and 2023. Technology trade protectionism. Other observers argue that TikTok is caught in the crosshairs of a global technology battle, and that a unilateral U.S. ban on any app may be comparable to China's Great Firewall. Footnote. The Great Firewall has been described as, quote, a system of surveillance and blocking technology that prevents Chinese citizens from viewing websites outside the country, end quote. End footnote. One way to potentially understand U.S. and Chinese government actions in this dispute may be through the concept of techno-nationalism, which refers to a country's refusal or reluctance to import other countries' advanced technology, as well as to export or to allow other nations to benefit from its own advanced technology. Within this framework, technology is considered a central pillar of a country's well-being. Quote, techno-nationalism links technological innovation and capabilities directly to a nation's national security, economic prosperity, and social stability. It seeks to attain competitive advantage for its stakeholders, both locally and globally, and leverage these advantages for geopolitical gain. End quote. One policy mechanism that nations use to protect what they view as important or sensitive technologies is export controls, rules that limit to which foreign entities and under what circumstances or conditions specific technologies may be sold or licensed. For example, in August 2020, the Bureau of Industry and Security at the Department of Commerce announced sanctions that restrict foreign semiconductor companies from selling chips developed or produced using U.S. software or technology to Huawei, another Chinese company, without first obtaining a license to do so. This restriction has been called a lethal blow to the company. Another mechanism is the use of protectionist practices that privilege domestic entities' access to domestic markets. For example, China requires U.S. telecommunications companies to enter a partnership with a Chinese company to provide services in that country. In June 2020, the Senate Committee on Homeland Security and Governmental Affairs Permanent Subcommittee on Investigations issued a report, Threats to U.S. Networks, Oversight of Chinese Government-Owned Carriers. The report notes that while China has access to the U.S. telecommunications market, U.S. companies do not have that same level of access in China. Quote, China does not provide U.S. telecommunications companies reciprocal access to the Chinese market and requires foreign carriers seeking to operate in China to enter into joint ventures with Chinese companies. These joint ventures often require U.S. companies to give their technology, proprietary know-how, and intellectual property to their Chinese partners. End quote. Since China was allowed to join the World Trade Organization in 2001, the report notes that, quote, not a single foreign firm has succeeded in establishing a new joint venture, end quote, to provide basic telecommunications services in China. Congressional action in the 118th Congress. Controversy followed TikTok from the 117th Congress into the 118th Congress. Some members have introduced various bills that would affect TikTok's ability to continue operating in the United States, and the House Committee on Energy and Commerce has held a hearing on TikTok. Legislation. Representative Michael McCall introduced the Deterring America's Technological Adversaries Data Act, House Bill 1153, House Report 118-63, on February 24, 2023. Among other provisions, the bill would require federal actions to protect the sensitive personal data of U.S. persons, with a particular focus on prohibiting the transfer of such data to foreign persons influenced by China. It would also require the Department of Treasury to issue a directive prohibiting U.S. persons from engaging in any transaction with any person who knowingly provides or may transfer sensitive personal data subject to U.S. jurisdiction to any foreign person subject to Chinese influence. The bill was reported by the Committee on Foreign Affairs on May 16, 2023, and placed on the Union calendar number 43, the same day. Representative Kat Kamik introduced the Chinese-owned Applications Using the Information of Our Nation, Caution Act of 2023, House Bill 750, on February 2, 2023. The bill would require any person who sells or distributes the social media application TikTok, or any service developed or provided by ByteDance Limited, to disclose prior to download that the use of the application is prohibited on government-owned devices. The bill was ordered to be amended on March 9, 2023 by the House Committee on Energy and Commerce. Representative Ken Buck introduced the No TikTok on United States Devices Act, House Bill 503, on January 25, 2023. Among other provisions, the bill would impose sanctions on the parent company of the TikTok social media service, ByteDance Limited, as long as it is involved with TikTok. Specifically, the president would be required to impose property-blocking sanctions on ByteDance or any successor entity or subsidiary if it is involved in matters relating to 1. TikTok or any successor service, or 2. Information, video, or data associated with such a service. Additionally, the bill would require the Office of the Director of National Intelligence, ODNI, to report to Congress on any national security threats posed by TikTok, including the ability of China's government to access or use the data of U.S. users of TikTok. Within 180 days of the bill's enactment, the Office of the Director of National Intelligence would be required to brief Congress on the implementation of the bill. On February 27, 2023, the bill was referred to the Subcommittee on the National Intelligence Enterprise. Senator Josh Hawley introduced the No TikTok on United States Devices Act, Senate Bill 85, on January 25, 2023. The bill is substantially similar to House Bill 503. On January 25, 2023, the bill was referred to the Committee on Banking, Housing, and Urban Affairs. Representative Brian Babin introduced the Terminate TikTok on Campus Act of 2023, House Bill 231, on January 10, 2023. The bill would prohibit federal funds from being provided to an institution of higher education unless the institution has banned use of TikTok on electronic devices. The bill was referred to the House Committee on Education and the Workforce the same day it was introduced. Representative Jack Bergman introduced the Protecting Personal Data from Foreign Adversaries Act, House Bill 57, on January 9, 2023. Among other provisions, the bill would authorize sanctions and other prohibitions relating to software that engages in user data theft on behalf of certain foreign countries or entities, and allow the president to regulate or prohibit transactions using software that engages in the theft or unauthorized transmission of user data and provides access to such data to a communist country, the Chinese Communist Party, a foreign adversary, or a state sponsor of terrorism. Additionally, the bill would allow the president to impose visa and property blocking sanctions on developers and owners of software that makes unauthorized transmissions of user data to servers located in China that are accessible by China's government or the Chinese Communist Party. It would also require the Department of State to determine and report to Congress whether WeChat or TikTok fall within certain regulations and prohibitions. Other bills introduced in the 118th Congress would likely impact TikTok without explicitly naming the company. For example, the Restrict Act, Senate Bill 686, would create new authorities for the Secretary of Commerce to review and prohibit certain information and communications technology, ICT, related transactions with foreign entities. These authorities could impact foreign entities such as TikTok. On January 9, 2023, the bill was referred to the Committee on Foreign Affairs and the Committee on the Judiciary for consideration of such provisions that fall within the jurisdiction of those committees. Hearing. On March 23, 2023, the House Committee on Energy and Commerce held a full committee hearing, TikTok, How Congress Can Safeguard American Data Privacy and Protect Children from Online Harms. During that hearing, members questioned the TikTok Chief Executive Officer, CEO, Shu Zichu, for approximately 5 hours about the safety and security of the app, including his company's relationship with China, possible teen addiction to the app, and misinformation being spread on the app. In particular, some members expressed concern that TikTok's parent company, ByteDance, might be sharing U.S. users' data with the Chinese government. After the hearing, a TikTok spokesperson, Brooke Oberwetter, stated that the day had been, quote, dominated by political grandstanding, end quote, that didn't acknowledge TikTok's current attempts to address the issues raised by the lawmakers. Oberwetter also noted, quote, not mentioned today by members of the committee, the livelihoods of the 5 million businesses on TikTok, or the First Amendment implications of banning a platform loved by 150 million Americans, end quote. The hearing does not appear to have settled the underlying dispute between the U.S. government and TikTok. There is no publicly available evidence that the Chinese government has accessed the information of U.S. users, but national security experts say it is a possibility. TikTok says that the Chinese government has never been shown to have influenced the app's recommendation algorithm, though experts say it is hypothetically possible. TikTok has admitted that company employees in China accessed the data of a few U.S. journalists, an incident that is being investigated by the Justice Department. Conclusion. The variety of apps available to U.S. users is enormous. Situations similar to the case of TikTok may arise in the future with other apps created by foreign companies. Congress may wish to consider various options to address such situations, including 1. Developing an overarching legal and regulatory framework to protect the security and privacy of U.S. citizens' data and communications, and 2. Establishing a uniform, transparent process to assess the risks posed by foreign apps and establish mechanisms to mediate those risks. Appendix. Related Congressional Activity 117th Congress. During the 117th Congress, 10 bills were introduced that would have affected the operation of TikTok in the United States. 1 became law. 4 hearings were held that focused on TikTok's operation in the United States. Laws. 1 TikTok-related bill became law in the 117th Congress. House Bill 2617, Public Law 117-328, Consolidated Appropriations Act 2023, introduced by Gerald E. Connolly on April 16, 2021, and became law on December 29, 2022. The law, which adopted the provisions of Senate Bill 1143, prohibits the installation and use of the TikTok app on devices owned by the federal government. Legislation. 10 TikTok-related bills that did not become law were introduced in the 117th Congress. House Bill 8772, Block the Talk Act, introduced by Representative Dusty Johnson and referred to the House Committee on Energy and Commerce Subcommittee on Consumer Protection and Commerce on September 6, 2022. This bill would have prohibited TikTok from accessing user data of U.S. citizens from within China and required the Federal Trade Commission to investigate whether TikTok engaged in unfair or deceptive practices. The bill also would have prohibited the download or use of TikTok at U.S. military installations, at certain federal agencies, and on federal government devices. House Bill 6837, No TikTok on Department of Homeland Security Devices Act, introduced by Representative Michael Guest and referred to the House Committee on Homeland Security Subcommittee on Oversight, Management, and Accountability on February 25, 2022. This bill would have prohibited Department of Homeland Security, DHS, employees and contractors from using TikTok on Department of Homeland Security computers or other information technology equipment. It also would have required the Department of Homeland Security to remove the application from Department of Homeland Security equipment. The bill included exceptions for law enforcement activities, national security interests and activities, and security researchers. House Bill 4793, Protecting Personal Data from Foreign Adversaries Act, introduced by Representative Jack Bergman on July 29, 2021, and referred to the House Committee on the Judiciary, Subcommittee Immigration and Citizenship, and Subcommittee on Courts, Intellectual Property, and the Internet on November 1, 2022. This bill would have authorized sanctions and other prohibitions relating to software that engage in user data theft on behalf of certain foreign countries or entities. It also would have allowed the President to regulate or prohibit transactions using software that engages in the theft or unauthorized transmission of user data and provides access to such data to 1. A communist country, 2. The Chinese Communist Party, 3. A foreign adversary, or 4. A state sponsor of terrorism. House Bill 4521, United States Innovation and Competition Act of 2021, introduced by Representative Eddie Bernice Johnson on July 29, 2021, and reported amended by the Committee on Science, Space, and Technology, passed/agreed to in the Senate on March 28, 2022. The bill would have required, with certain exceptions, that executive agencies remove TikTok and similar apps from their information technology. House Bill 3057, ACES Act of 2021. Introduced by Representative Lisa C. McLean on May 7, 2021, and referred to the House Committee Energy and Commerce Subcommittee on Consumer Protection and Commerce on May 10, 2021. This bill would have required certain actions related to ByteDance Limited, the Chinese parent company of TikTok, including requiring ByteDance to divest itself of assets or property used to enable or support ByteDance's operation of TikTok in the United States. Senate Bill 1260, United States Innovation and Competition Act of 2021, introduced by Senator Charles E. Schumer on April 20, 2021, and passed the Senate on June 8, 2021. The bill would have required, with certain exceptions, that executive agencies remove TikTok and similar apps from their information technology. House Bill 2566, No TikTok on Government Devices Act, introduced by Representative Ken Buck and referred to the House Committee on Oversight and Reform on April 15, 2021. This bill would have required, with certain exceptions, that TikTok be removed from the information technology of federal agencies. Senate Bill 1143, No TikTok on Government Devices Act, introduced by Senator Josh Hawley on April 15, 2021, and received and held at the desk in the House on December 15, 2022. This bill was included as Section 102 of Division R of the Consolidated Appropriations Act 2023, Public Law 117-328, and requires TikTok to be removed from the information technology of federal agencies. Senate Bill 47, App Act, introduced by Senator Marco Rubio and referred to the Senate Committee on Commerce, Science, and Transportation on January 26, 2021. This bill would have established requirements for owners and operators of certain software, such as TikTok, from specified countries who make their software available to consumers in the United States. For example, before making such software available for download, the software would have been required to provide users with a warning to include the name of the owner and the owner's country of principal operation. Hearings. 3 hearings were held in the Senate and 1 joint hearing was held that focused on issues related to TikTok. U.S.-China relations, improving U.S. competitiveness through trade. Senate hearing 117-351. Senate Committee on Finance, April 22, 2021. Congressional Executive Commission on China, Annual Report 2022. Joint hearing, November 3, 2022. Emerging Technologies and Their Impact on National Security, Senate Hearing 117-148, Senate Committee on Armed Services, February 23, 2021. Nominations of the 117th Congress, Second Session, Part 2, Senate Hearing 117-642, Senate Committee on Foreign Relations, June 23, 2022 through November 30, 2022. End of Section 1. Read by Elsie Selwyn. Section 2 of TikTok, Collected Reports, by Various. This LibriVox recording is in the public domain. Restricting TikTok, Part 1, Legal History and Background, by Stephen P. Mulligan. Released September 28, 2020. The video sharing platform TikTok has experienced a dramatic rise in users in the United States in recent years, while at the same time some members of Congress and Biden administration officials have described the app as a national security threat. During the Trump administration, concerns about TikTok's data security and connections to the People's Republic of China, PRC, led to the attempt to restrict the app's U.S. operations. In decisions that informed the current legislative debate, 2 federal district courts concluded that aspects of the restrictions were unlawful because they exceeded the president's statutory authority. Other elements of the Trump administration's efforts have been continued by the Biden administration and are ongoing. This sidebar discusses these past executive branch-led efforts. A companion sidebar examines current legislative proposals to restrict TikTok and constitutional and other legal considerations for Congress to consider when crafting legislation. Other Congressional Research Service products discuss legal challenges to Montana's ban of the app and policy options to address related data privacy and national security concerns posed by TikTok. Trump administration initiatives. President Trump sought to leverage 2 legal frameworks to restrict TikTok's U.S. presence and operations. The International Emergency Economic Powers Act, IEEPA, and the legal authorities underpinning the Committee on Foreign Investment in the United States, CFIUS. International Emergency Economic Powers Act-based restrictions. As discussed in the Congressional Research Service report, the International Emergency Economic Powers Act, Origins, Evolution, and Use. The International Emergency Economic Powers Act authorizes the President to regulate a variety of commercial transactions and to block, i.e. freeze, foreign-owned property and assets subject to the jurisdiction of the United States. Before invoking these authorities, the President, following the procedures of the National Emergencies Act, must declare a national emergency related to an, quote, unusual and extraordinary threat, which has its source in whole or substantial part outside the United States, end quote. In 2019, President Trump laid the groundwork to invoke the International Emergency Economic Powers Act by declaring a national emergency, 2019 Emergency Declaration, based on foreign adversaries' ability to exploit vulnerabilities in the U.S. Information and Communication Technology and Services, ICTS, supply chain. In August 2020, the President issued an executive order, 2020 order, which invoked the President's International Emergency Economic Powers Act authority to restrict TikTok's U.S. operations in response to the Information and Communication Technology and Services emergency. Under authority delegated by the 2020 order, the Secretary of Commerce issued a list of prohibited transactions, which included maintaining TikTok on a mobile app store or providing internet hosting services to it. Contemporaneously, President Trump issued another executive order, WeChat order, that restricted U.S. operations of WeChat, a People's Republic of China-based messaging, social media, and electronic payment app, discussed in the Congressional Research Report TikTok Technology Overview and Issues. This sidebar largely focuses on TikTok regulation except when the WeChat order may be relevant. Judicial challenges to the International Emergency Economic Powers Act-based restrictions. Two sets of lawsuits followed the Trump administration's International Emergency Economic Powers Act-based restrictions on TikTok, one filed by TikTok and its parent company ByteDance Limited, and another by a group of TikTok users. The plaintiffs in both suits raised several statutory and constitutional claims that the restrictions were unlawful, but the court's decision focused on whether the Trump administration exceeded its statutory authority by regulating conduct that fell into the International Emergency Economic Powers Act's exceptions. While the International Emergency Economic Powers Act grants extensive authority to the President to restrict or prohibit transactions under certain conditions, the statute also lists categories of conduct that the President cannot regulate. Two exceptions were the focus of the litigation. Under the personal communication exception, the President may not restrict, quote, any postal, telegraphic, telephonic, or other personal communication which does not involve a transfer of anything of value, end quote. Under the informational materials exception, sometimes called the Berman Amendment after its legislative sponsor, Representative Howard Berman, the President cannot restrict most, quote, information or informational materials, including but not limited to publications, films, posters, phonograph records, photographs, artworks, and newswire feeds, end quote. The plaintiffs argued that TikTok's core function, creating and sharing short-form videos, involved transmitting personal communications and informational materials, albeit in a modern format. The Department of Commerce had sought to avoid this argument by limiting its restrictions to business-to-business transactions, rather than TikTok users' personal exchange of communication and information. The courts ultimately sided with the plaintiffs and issued preliminary injunctions temporarily barring the United States from enforcing the restrictions. Both courts described the government actions as effectively banning TikTok from operating in the United States. In the case brought by TikTok and ByteDance, the court concluded that the plaintiffs were likely to prevail on the argument that the ban ran afoul of both relevant exceptions. In the TikTok users' case, the court limited its decision to the information materials exception. A group of WeChat users also challenged the Trump administration's restrictions on that app in a separate case. A federal district court similarly granted a preliminary injunction in favor of the WeChat users, but it did so on First Amendment grounds, which are analyzed in Part 2 of this sidebar. The United States appealed the injunctions in both sets of cases. After the Biden administration withdrew the underlying executive orders in June 2021, the parties agreed to voluntarily dismiss all of the cases before the appeals were decided. Committee on Foreign Investment in the United States review. The Trump administration's other public TikTok initiative, which the Biden administration has not withdrawn, is based on the Committee on Foreign Investment in the United States process. The Committee on Foreign Investment in the United States is an interagency committee chaired by the Secretary of the Treasury that reviews foreign investments in the United States for potential national security risks. Its statutory authority derives from Section 721 of the Defense Production Act, as amended and codified in Volume 50 of the United States Code, Section 4565. The Committee on Foreign Investment in the United States traditionally reviews mergers, acquisitions, and takeovers that could result in a foreign entity taking control of a U.S. business. Amendments to its statutory authorities enacted in 2018 expanded the Committee on Foreign Investment in the United States' jurisdiction to cover a select set of non-controlling investments and real estate transactions. When a transaction falls in its ambit and the Committee on Foreign Investment in the United States determines there is sufficient national security risk, the Committee on Foreign Investment in the United States can impose mitigation measures and recommend to the President whether to prohibit or suspend the transaction. The President has the ultimate authority to prohibit or suspend a covered transaction if the President finds there is credible evidence that the transaction would threaten to impair national security and could not be addressed using authorities in other laws. The President's authority to block transactions is both forward and backward-looking, meaning presidents can block planned transactions and require parties to divest, i.e. unwind, completed deals. In TikTok's case, the Committee on Foreign Investment in the United States' review concerned ByteDance's acquisition of another video-based social media company called Musical.ly. ByteDance purchased Musical.ly for $1 billion in 2017 and merged its operations into the TikTok app the next year. By 2020, President Trump concluded that this acquisition threatened U.S. national security and issued an divestment order, directing ByteDance to divest 1. Its assets used to support TikTok's U.S. operations, and 2. Data obtained or derived from TikTok or Musical.ly users in the United States. TikTok and ByteDance filed a judicial challenge in November 2020, arguing that the divestment order violated constitutional protections against taking private property without just compensation and deprived them of their due process rights under the Fifth Amendment. TikTok and ByteDance also argued that the order did not comply with the statutory requirements in the Administrative Procedure Act. After the transition to the Biden administration, TikTok, ByteDance, and the executive branch jointly requested that the court hold the case in abeyance, while the parties sought to determine whether the case could be resolved by agreement. The court granted that request in February 2021 and directed the parties to file status reports every 60 days. According to the status report submitted in August 2023, the parties continue to negotiate whether the litigation can be resolved by mutual agreement. The Committee on Foreign Investment in the United States has not formally commented on these negotiations, but TikTok has publicly described some elements of the negotiations in letters to members of Congress and in briefings to the media. The Information and Communications Technology and Services (ICTS) Supply Chain Rule and Data Executive Order. In January 2021, the Department of Commerce issued an interim final rule and request for comments, Supply Chain Rule, that does not name TikTok directly, but could be relevant to U.S. efforts to restrict the app's operations. Discussed in the In Focus report, the Information and Communications Technology and Services ICTS Rule and Review Process, the Supply Chain Rule creates a new interagency process led by the Department of Commerce that can review certain information and communication technology and services transactions, a term now broadly defined in regulation. If a covered information and communication technology and services transaction involves foreign adversaries and presents certain undue or unacceptable risks identified in the precursor executive order, the Department of Commerce can either prohibit the transaction or negotiate mitigation measures to address national security risks. In June 2021, President Biden expanded on the supply chain rule through an executive order titled Protecting Americans' Sensitive Data from Foreign Adversaries, Data Executive Order. The Data Executive Order rescinded several Trump administration orders, including the 2020 order and WeChat order, and replaced them with new initiatives designed to address risks posed by foreign-owned and controlled apps. The Data Executive Order left other Trump-era orders in place, including the 2019 Emergency Declaration and the Divestment Order. As one initiative, the Data Executive Order directed Commerce to consider special criteria when evaluating whether to block information and communication technology and services transactions that involve apps under the supply chain rules review process. In a June 2023 final rule, the Department of Commerce added new app-specific risk factors and clarified that transactions involving apps may be subject to the supply chain rule. Some observers viewed these developments as a signal that the Biden administration would use the supply chain rules review process to restrict foreign-owned apps like TikTok. As of September 2023, Commerce has not blocked any transactions using the supply chain rule, and its only public action under the rule has been to subpoena the People's Republic of China-based companies that provide information and communication technology and services in the United States. One possible explanation for the lack of executive action may be the supply chain rule's legal foundations. The authorities that undergird the rule include elements of the International Emergency Economic Powers Act and the 2019 Emergency Declaration, the same authorities used for the 2020 order that was enjoined by federal courts and later rescinded. Because the supply chain rule is International Emergency Economic Powers Act based, it is likely that it will be subject to the same personal communications and informational materials exceptions that were at issue in litigation during the Trump administration. The limitations that the International Emergency Economic Powers Act's exceptions place on the president's power to restrict cross-border transactions have led some members of Congress to propose additional legislative authorities that, among other things, would remove the personal communications and informational materials exceptions. These proposals and the constitutional provisions that they could implicate are explored in a second installment of this two-part sidebar. End of Section 2, read by Elsie Selwyn. Section 3 of TikTok, Collected Reports, by Various. This LibriVox recording is in the public domain. Restricting TikTok Part 2, Legislative Proposals and Considerations for Congress, by Peter J. Benson, Valerie C. Brannon, Joanna R. Lampe, Christopher D. Lindbaugh, and Stephen P. Mulligan. Released March 15, 2024. This legal sidebar is the second installment in a two-part series on U.S. efforts to regulate the video sharing application app, TikTok. The first installment provided legal background on executive branch-led efforts to restrict TikTok's U.S. presence and operations. This sidebar analyzes proposals to create new authorities to restrict TikTok and examines constitutional and other legal issues for Congress to consider. Legislative proposals. Against the backdrop of executive branch efforts discussed in Part 1 of this series, the 118th Congress is considering legislative proposals that would address TikTok's alleged national security risks. On March 13, 2024, the House passed the Protecting Americans from Foreign Adversary-Controlled Applications Act, House Bill 7521, which would prohibit app stores and internet hosting services from supporting TikTok unless it undergoes a qualified divestment that removes it from foreign adversary control. A number of other bills have also been introduced that would authorize or require the executive branch to restrict transactions involving TikTok. These bills are discussed further below, and several distinctions among them are outlined in Table 1. House Bill 7521. House Bill 7521 would prohibit app stores and internet hosting services from enabling the distribution, maintenance, or updating of, quote, foreign adversary-controlled applications, end quote. The bill would also require foreign adversary-controlled applications to provide, upon request, U.S. users with all the data related to their accounts, including their posts, photos, and videos, in a, quote, machine-readable format, end quote. A company that violates either restriction could be fined in an amount based in part on the number of users affected by the violation. The bill defines foreign adversary-controlled application to include TikTok and any other subsidiary of ByteDance Limited, TikTok's parent company. The definition also includes any other website, app, or augmented or immersive technology that 1. Meets certain definitional requirements, such as allows users to share content with each other and has more than 1 million monthly active users. 2. Is owned by a company located in, or a company for which persons owning at least a 20% stake are located in, a foreign adversary-controlled country listed in Volume 10 United States Code Section 4872 D2, and 3. Has been determined by the President to present a significant national security threat. House Bill 7521's restrictions would not apply to TikTok or any other foreign adversary-controlled application if they complete a, quote, qualified divestiture, end quote, which is any transaction that, per a presidential determination, ends the application's control by or coordination with a foreign adversary. The bill would give TikTok and any other foreign adversary-controlled application 180 days to complete a qualified divestiture before the bill's restrictions apply. For applications operated by TikTok or other subsidiaries of ByteDance, the qualified divestment period would follow the bill's date of enactment. If the President determines that another application qualifies as a foreign adversary-controlled application, the 180-day period would be tied to the date of the applicable presidential determination. Even after this 180-day period ends, the bill's restrictions would cease to apply once a qualified divestiture has been completed. House Bill 7521 would be enforced by the Attorney General, who would be authorized to bring actions for civil penalties in a federal district court. House Bill 7521 would require that any legal challenges to the law, or the President's determinations under the bill, be brought in the U.S. Court of Appeals for the D.C. Circuit. Other bills that would authorize or require TikTok restrictions. In addition to House Bill 7521, a number of other bills have been introduced in the 118th Congress that seek to address national security concerns related to TikTok. While each bill has unique provisions, general trends across multiple bills include the following features. Removing International Emergency Economic Powers Act exceptions. One common element in many TikTok-related bills is to eliminate exceptions to the President's statutory powers under the International Emergency Economic Powers Act. These proposed provisions seek to address the legal grounds discussed in Part 1 on which two courts enjoined the Trump administration's August 2020 executive order, 2020 order, that would have imposed a nationwide ban of TikTok. Examples of legislation in this category include the No TikTok on United States Devices Act, House Bill 503/Senate Bill 85, and the Averting the National Threat of Internet Surveillance, Oppressive Censorship and Influence, and the Algorithmic Learning by the Chinese Communist Party Act, Anti-Social CCP Act, House Bill 1081/Senate Bill 347. Removing International Emergency Economic Powers Act exceptions and adding new authorities. Some bills that would limit the International Emergency Economic Powers Act exceptions would also provide the executive branch new authorities and obligations beyond the International Emergency Economic Powers Act. The Protecting Personal Data from Foreign Adversaries Act, House Bill 57, for example, would authorize the President to invoke the International Emergency Economic Powers Act and impose visa restrictions in response to certain foreign entities' misuse of social media apps. The Stopping Attempts by Foreign Entities to Target Youths on Social Media Act of 2023, Safety on Social Media Act of 2023, Senate Bill 872, would authorize International Emergency Economic Powers Act actions, mandate visa restrictions on foreign persons employed by designated companies, and require U.S. nationals employed by designated companies to register as foreign agents under the Foreign Agents Registration Act. The Deterring America's Technological Adversaries Act, DATA Act, House Bill 1153, would allow the President to use the International Emergency Economic Powers Act authorities while also giving the Secretary of the Treasury new powers to prohibit transactions with parties that knowingly provide sensitive personal data of persons subject to U.S. jurisdiction to companies subject to the People's Republic of China's ownership, control, jurisdiction, or influence. Non-International Emergency Economic Powers Act-based review systems. Some legislation would create new systems not linked to the International Emergency Economic Powers Act to review transactions for national security risks. For example, the Safety on Social Media Act of 2023 would require the Federal Communications Commission, FCC, to issue rules that prohibit certain platforms designated by the President from being carried in app stores, and rules that require Internet service providers to block designated entities from receiving Internet services. The Restricting the Emergence of Security Threats that Risk Information and Communications Technology Act, Restrict Act, Senate Bill 686, would authorize two new non-International Emergency Economic Powers Act-based national security review programs. The Restrict Act invokes elements of two existing review systems discussed in Part 1 of the sidebar, the Information and Communications Technology and Services ICTS Supply Chain Rule, and the Committee on Foreign Investment in the United States, CFIUS. Unlike the Supply Chain Rule, the bill's proposed process to review information and communication technology and services transactions would not depend on the International Emergency Economic Powers Act for its underlying authority, and therefore would not be subject to the International Emergency Economic Powers Act's exceptions. The Restrict Act would also create a new Committee on Foreign Investment in the United States-like process for the executive branch to review foreign adversaries' holdings, i.e. investments, in information and communication technology and services companies. Biden administration officials have expressed support for the bill. Other frameworks. In addition to bills authorizing actions that could restrict the availability of TikTok, legislation expanding data privacy frameworks could impose limitations on what TikTok could do with personal data. Other legislative proposals in the 118th Congress would create new restrictions on cross-border transfer of personal data by subjecting some categories of personal data to export controls. Another set of bills would require companies to provide notices to U.S. users if the company's apps are banned from U.S. government devices, have certain connections to the People's Republic of China or Chinese Communist Party, CCP, or allow the People's Republic of China or the Chinese Communist Party to access Americans' user data. Considerations for Congress. Anytime Congress considers legislation that could allow the United States to regulate private commercial transactions on national security grounds, a variety of constitutional and legal considerations may be relevant. Given TikTok's popularity and role as a platform that facilitates personal expression and exchange of information, several issues are especially salient. First Amendment. Regulating mediums of expression can trigger the First Amendment's protections for speech and association. In the litigation challenging the Trump administration's restrictions on TikTok, and in the separate case challenging similar restrictions on the WeChat app, which are discussed in Part 1, the plaintiffs allege the executive branch violated the First Amendment by shutting down these platforms for speech. State laws limiting TikTok use or operations have also been subject to First Amendment challenges, and in November 2023, a federal trial court entered a preliminary injunction preventing a Montana ban on the app from taking effect, citing the First Amendment among other grounds. That Montana ruling has been appealed to the U.S. Court of Appeals for the Ninth Circuit. Laws that affect non-expressive conduct rather than speech may avoid constitutional scrutiny, But First Amendment protections will be triggered if a law targets expressive conduct or, quote, has the inevitable effect of singling out those engaged in expressive activity, end quote. If a regulation specifically targets a medium of communication as opposed to generally regulating a variety of businesses, it might trigger heightened constitutional scrutiny. Accordingly, the Montana court concluded that the state's law targeted expressive activity by banning a means of expression. Even if a regulation is aimed at a platform's non-expressive conduct, First Amendment concerns can arise if that law is applied to speech. For instance, the Berman Amendment added the informational materials exception to the International Emergency Economic Powers Act in response to executive branch seizures of magazines and books that Congress said were protected by the First Amendment. While foreign corporations outside U.S. territory do not benefit from First Amendment rights, separately incorporated organizations within the United States may enjoy First Amendment protections. Further, the Supreme Court has long recognized that U.S. citizens have a right to receive information and ideas from abroad. TikTok and WeChat users in the United States also challenged the Trump administration's restrictions by raising their own rights to receive and share content. Assuming that a particular regulation broadly affects all speech on the regulated platform and does not target particular viewpoints or types of content, a court would likely review any First Amendment claims under an analysis known as intermediate scrutiny. This constitutional standard applies to regulations that are content neutral, or only incidentally restrict speech, in the course of permissibly regulating conduct. The standard generally requires the government to show the regulation, quote, furthers an important or substantial government interest, end quote, that is, quote, unrelated to the suppression of free expression, end quote, and that, quote, the incidental restriction on alleged First Amendment freedoms is no greater than is essential to the furtherance of that interest, end quote. Courts might also ask whether a regulation, quote, leaves open ample alternative channels for communication, end quote, of the affected speech. It is also possible certain types of regulations might be challenged as prior restraints on speech, triggering additional constitutional considerations. In addition, a higher constitutional standard might apply if there is evidence the government targeted a platform because of its viewpoint or the type of speech it hosts, or if the law is otherwise content-based. The courts reviewing the WeChat ban and the Montana state law both held that the restrictions likely failed intermediate scrutiny. The WeChat ruling acknowledged the government's significant interests in national security, an area where courts have sometimes been more deferential to the political branches. Nonetheless, that court concluded the restrictions were not appropriately tailored to this interest, noting, quote, obvious alternatives to a complete ban, such as barring WeChat from government devices, or taking other steps to address data security, end quote. The Montana court similarly ruled that the state's law burdened substantially more speech than necessary, saying the state's, quote, single investigation into TikTok, end quote, did not warrant a complete ban. Courts applying intermediate scrutiny must look closely at the government's evidence to ensure, quote, that the recited harms are real, not merely conjectural, and that the regulation will in fact alleviate these harms in a direct and material way, end quote. This inquiry is heavily dependent on context, and Congress might consider whether to include evidence demonstrating these elements in the legislative record. Due process. Congress may also consider whether TikTok-related bills afford sufficient safeguards to comply with procedural due process standards. When a person is deprived of a protected property right, the Fifth Amendment's Due Process Clause requires the United States to provide notice of the government action and a meaningful opportunity to contest it. Due process protections apply to foreign individuals and entities that enter U.S. territory and establish substantial connections with the United States. In one relevant example, a federal court of appeals held that, before the president could order a People's Republic of China-based company to divest an acquisition under the Committee on Foreign Investment in the United States process, the government needed to provide the affected company with the unclassified information on which it based its decision, and the chance to respond. Due process standards may be different when Congress directly affects property rights through a legislative determination rather than through a judicial or administrative process. For legislative determinations, the legislative process may provide, quote, all the process that is due, end quote, unless the law is palpably arbitrary. Takings Clause. Litigants have sometimes argued that U.S. restrictions on cross-border transactions and investments violate the Fifth Amendment's Takings Clause, which prohibits the United States from taking private property for public use without just compensation. The Takings Clause applies to the actual acquisition of property and to regulatory actions that so severely restrict a property owner's rights that they rise to the level of a regulatory taking. In the context of foreign actors asserting constitutional rights, the Takings Clause protects foreign individuals and entities with substantial connections to the United States, including those whose property in the United States is taken by the federal government. Although Takings Clause challenges to the International Emergency Economic Powers Act-based actions have been largely unsuccessful, some plaintiffs continue to raise them. In TikTok's challenge to the 2020 order, for example, the company argued that President Trump's discussion of securing a payment to the Department of the Treasury if TikTok were to be sold to an American company amounted to an attempt to secure an unconstitutional taking. This issue did not ultimately feature in the court's opinion, as the court based its decision on the International Emergency Economic Powers Act interpretation issues. Bill of Attainder. The Bill of Attainder clause has also been a topic of discussion in TikTok-related legislation. This clause prohibits Congress from using legislation to determine guilt and inflict punishment without a judicial trial. As explored in the Congressional Research Service In Focus report, Sanctions Legislation in the Bill of Attainder Clause, there are several unresolved questions about whether the clause applies to modern economic restrictions on foreign corporations. In two recent judicial challenges, courts held that legislation restricting transactions with the People's Republic of China-based Huawei and Russia-based Kaspersky Lab did not violate the Bill of Attainder Clause because the laws sought to protect U.S. security, not punish a private actor. Proposals that would provide for judicial trial or agency action before imposing applicable sanctions, such as House Bill 7521, would not violate the Bill of Attainder Clause. Other legal considerations. Apart from constitutional considerations, Congress may consider procedural and statutory issues that could affect how proposed TikTok restrictions operate. A selection of these issues are discussed below. Judicial review. Congress could consider legislative mechanisms to limit or streamline judicial review of challenges to any new transaction restriction authorities it enacts. Some existing statutes limit judicial review of similar restrictions by exempting the decision to impose restrictions from the Administrative Procedure Act, APA, or from judicial review in general. Some laws require legal challenges to be brought before a specific court, usually the U.S. Court of Appeals for the D.C. Circuit, because of its familiarity with special procedures in cases involving classified information. Among TikTok-related bills, the Restrict Act would limit judicial review to actions that are, quote, unconstitutional or in patent violation of a clear and mandatory statutory command, end quote, and give the D.C. Circuit exclusive jurisdiction over those cases. House Bill 7521 would grant the D.C. Circuit, quote, exclusive jurisdiction over any challenge to this act or any action, finding, or determination under this act, end quote, and impose a short statute of limitations for bringing such challenges. Classified and other sensitive information. In anticipating judicial challenges, Congress may consider prescribing how courts handle classified and other legally protected information during litigation. The Committee on Foreign Investment in the United States statute is one example of streamlined procedures. It provides that if a court determines that classified or other protected information that is in the administrative record is necessary to resolve a legal challenge, that information must be submitted ex parte and in camera, i.e., only the court may view it, and maintained under seal so that it cannot be made public. The Committee on Foreign Investment in the United States statute also exempts the United States from statutory requirements to provide notice to U.S. persons when using information obtained under the Foreign Intelligence Surveillance Act of 1978, FISA. Confidentiality and Freedom of Information Act. When Congress creates new processes to review private commercial transactions, it may seek to balance public interest in the process with the private entity's desire for confidentiality. Some existing national security review systems prohibit the government from disclosing parties' private information gathered during the review process unless an exception applies. The Committee on Foreign Investment in the United States' legal authorities provide even stricter confidentiality by stating that materials submitted during its review process are exempt from the Freedom of Information Act, FOIA, absent an exception. The Data Act places certain special confidentiality requirements on Congress, and the Restrict Act generally incorporates the Committee on Foreign Investment in the United States' confidentiality rubric and the Freedom of Information Act exemption. Naming TikTok. Another topic of discussion is whether legislation should identify TikTok by name. Whether TikTok is identified in a bill's text can be relevant in a bill of attainder challenge as part of a broader argument that the government targeted the company for punishment. The scope of coverage could also be relevant for First Amendment purposes to determine whether the law singles out expressive activity or disfavored speakers. In addition, the issue might feature in the due process context if Congress were to make a legislative determination that TikTok presents a national security threat. Some proposals in the 118th Congress expressly include TikTok among a defined set of entities with whom transactions would be restricted. Other bills name TikTok but do not mandate that the bill's restrictions apply to it. Instead, these proposals would require a presidential determination on whether the bill's provisions apply to the company. A third step would create transaction review frameworks that the executive branch could interpret to include TikTok, but that do not name the company in the legislative text. House Bill 7521 specifically names TikTok and also authorizes the president to determine that additional applications should be subject to the bill's restrictions. Congressional oversight. Congress may consider options to ensure that it is informed about executive branch actions in implementing any legislation that passes and can exercise effective oversight. For example, the No TikTok on American Devices Act would require the executive branch to provide a classified briefing on its implementation of the bill. Another example is the Data Act, which would require the president to share information about the bill's implementation with designated congressional committees. The Data Act also proposes to facilitate greater congressional involvement by requiring the president to respond to the designated committees' requests for determinations on whether specific individuals or entities are subject to the bill's sanctions and restrictions. End of Section 3, read by Elsie Selwyn. Section 4 of TikTok, Collected Reports by Various. This LibriVox recording is in the public domain. Montana's TikTok ban, an injunction and pending legal actions. By Sanchita Jayaram and Madeline W. Donnelly. Released December 8, 2023. On November 30, 2023, a U.S. district judge issued a preliminary injunction preventing Montana from enforcing a ban on TikTok's operations in the state. According to media reporting, while a number of states have some type of prescription of TikTok platform usage, Montana's law, Montana Senate Bill 419, represents the first attempted ban of this breadth among U.S. states. This legal sidebar, 1. Briefly describes Montana Senate Bill 419, 2. Discusses legal challenges to the law, 3. Explains the primary basis for the preliminary injunction, and 4. Highlights some topics that these legal challenges might raise for Congress. Montana Senate Bill 419 attempts to restrict TikTok's Montana operations. Public information about the reasons for Montana's TikTok legislation abounds. Montana Senate Bill 419's preamble states that the law promotes the, quote, health and safety of Montanans, end quote, and lists concerns including the People's Republic of China's status as, quote, an adversary, end quote, as well as TikTok's status as a, quote, subsidiary of a Chinese corporation, end quote, over which, quote, the People's Republic of China exercises control and oversight, end quote, improper procurement and sharing of user data, and promotion of, quote, dangerous content, end quote. Analysis of these claims, as well as the broader policy issues prompted by the legislation, is beyond the scope of this legal sidebar. Montana Senate Bill 419 would ban TikTok in Montana by 1. Prohibiting mobile application app stores from making the TikTok app available to users in Montana. 2. Prohibiting TikTok's operation in all places subject to Montana's criminal jurisdiction. And 3. Including penalties and enforcement provisions. Absent the preliminary injunction, Montana Senate Bill 419 would become effective January 1, 2024, assuming no trigger of a novel clause that could void the law, quote, if TikTok was acquired by or sold to a company that is not incorporated in any other country designated as a foreign adversary in Volume 15 of the Code of Federal Regulations, Section 7.4, at the time TikTok is sold or acquired, end quote. The referenced Code of Federal Regulations provision implements Executive Order 13,873, Securing the Information and Communications Technology and Services Supply Chain, discussed in the Congressional Research Service In Focus report, the Information and Communications Technology and Services ICTS Rule and Review Process. To date, no other states have enacted a ban this broad against TikTok or any other social media platform. Instead, more than half of U.S. states prohibit the use of TikTok on at least some state-issued devices. A number of public post-secondary institutions have followed suit, enacting policies that prevent university Wi-Fi or university-issued devices from being used to access the app. Utah, Arkansas, Texas, and Louisiana all passed legislation in 2023 restricting children's access to social media platforms, including TikTok, and similar legislation has been introduced in other states. Court preliminarily blocks ban on constitutional grounds. In issuing the preliminary injunction which prevents Montana State Bill 419 from taking effect until the court's final resolution of the dispute on the merits, the district court cited several constitutional concerns with the law. TikTok's complaint asserts violations of several constitutional rights and provisions, including those related to bills of attainder, the Commerce Clause, the First Amendment, and the Supremacy Clause. Other challengers, a group of TikTok creators and users, raised similar arguments, and the court consolidated the suits. Brief description of these constitutional concepts, ordered as they appear in the TikTok complaint and then the other user's complaint, and how they might apply and the final determination follow. First Amendment. The First Amendment protects free speech and association. TikTok's challenge asserts that Montana State Bill 419 unconstitutionally violates its First Amendment rights, in part by using a content-based justification to effectively shut down the platform. TikTok claims a right to exercise editorial judgment on how to transmit speech, while users argue the law limits their rights to speak on the platform. Similar challenges arose in response to earlier Trump administration restrictions on TikTok and WeChat. Supremacy Clause, Preemption. The Supremacy Clause establishes the Constitution and the laws of the United States as the, quote, supreme law of the land, end quote. The Supreme Court has understood this clause to mean that federal law preempts conflicting state law, rendering it unenforceable. When state law conflicts with a specific federal law, that is called conflict preemption. In certain contexts, federal interests may be so dominant as to occupy certain fields of law entirely, known as field preemption. Based on these principles, there are areas where state legislation is invalid. TikTok argues that Montana Senate Bill 419 is federally preempted because the regulation of a foreign-owned app to secure U.S. user data interferes with the exclusive federal powers over foreign affairs and national security. Other specific preemption arguments from the users appear below. Commerce Clause. The Commerce Clause confers upon Congress the power to regulate interstate and foreign commerce and restricts states from impairing such commerce. The Dormant Commerce Clause doctrine prohibits certain kinds of regulatory discrimination by states against out-of-state economic interests. TikTok alleges that Montana State Bill 419 violates the Commerce Clause by unduly burdening interstate and foreign commerce through a ban that is, quote, state-specific, but that risks disrupting the flow of travel and commerce between states, end quote. Bills of Attainder. Article 1 of the Constitution prohibits bills of attainder, which the Supreme Court has interpreted to include laws that impose forms of punishment without a trial. TikTok alleges that Montana Senate Bill 419 is an unconstitutional bill of attainder because, in TikTok's view, the law targets TikTok alone rather than regulating social media companies generally. Similar challenges by Huawei and Kaspersky Lab in recent years to other government actions did not succeed. 14th Amendment. The Due Process Clause of the 14th Amendment provides that no state shall, quote, deprive any person of life, liberty, or property without due process of law, end quote. TikTok users argue that Montana State Bill 419 violates the 14th Amendment by depriving Montanans of their property and liberty interests in using TikTok, and that the state did so without providing adequate notice or opportunity for users to respond. The International Emergency Economic Powers Act, IEEPA. The International Emergency Economic Powers Act gives the President regulatory authority over a variety of economic transactions in the event of a national emergency that constitutes an unusual and extraordinary threat. Executive Orders 13,873 and 14,034 invoked the International Emergency Economic Powers Act authority in response to concerns about foreign adversaries' access to American digital data. As discussed in the Legal Sidebar Report Restricting TikTok Part 1 Legal History and Background, the executive branch imposed and then withdrew the International Emergency Economic Powers Act-based restrictions on TikTok. The users allege that Montana State Bill 419 conflicts with the International Emergency Economic Powers Act and the executive orders, and is therefore preempted because it undermines the executive branch by imposing a ban that the executive branch rescinded. Section 721 of the Defense Production Act. Section 721 gives the President and the Committee on Foreign Investment in the United States, CFIUS, authority to review certain transactions with foreign parties to determine, quote, the effects of the transaction on the national security of the United States, end quote. The users argue that Montana State Bill 419 is preempted because it prevents the President and the Committee on Foreign Investment in the United States from exercising their authority under Section 721 by preventing them from placing conditions on TikTok's operation in the United States. On the basis of these claims, the plaintiffs together sought a preliminary injunction against Montana Senate Bill 419. Attorneys for Montana responded that the law represents the valid exercise of Montana's police power and does not violate any of the claimed constitutional provisions, that federal law does not preempt the ban, and that the ban would have only an indirect and thus permissible effect on interstate commerce. The court found the plaintiffs' arguments compelling, determined they likely would succeed on the merits, and granted the preliminary injunction. Some aspects of the plaintiffs' constitutional arguments that the court found persuasive follow. First Amendment. The court concluded the ban would not likely survive even a medium level of scrutiny, called intermediate scrutiny, with respect to the First Amendment claim. The court based this conclusion in part on its view that Montana did not have a compelling government interest in foreign affairs, an area where states do not have constitutional authority. The court also said the preamble to the law was indicative of an anti-Chinese purpose. Even if Montana did have a compelling interest, the court found that the law is likely not, quote, narrowly tailored, end quote, in part because it would burden more speech than necessary to meet its interests. Supremacy Clause, Preemption. The court determined that Montana State Bill 419 would likely be preempted via foreign affairs field preemption and at least one instance of conflict preemption. The court did not find persuasive Montana's argument that the law serves a consumer protection purpose and found its novel avoidance clause, triggered upon sale of the company, indicative of its true foreign affairs purpose. Further, the court found reports of ongoing Committee on Foreign Investment in the United States negotiations with TikTok, pursuant to the Defense Production Act, to represent at least one instance of conflict preemption. Commerce Clause. The court found that Montana did not provide sufficient evidence of the law's significant local benefit as contrasted to the attendant burden on interstate commerce. The court also agreed with plaintiffs that the law facially discriminates against commerce with China, a concept Montana did not contest. After finding that the plaintiffs established irreparable harm to their business interests, the court granted the preliminary injunction. Relevance for Congress. Several issues raised by Montana State Bill 419 and the challenges to it mirror potential considerations for Congress in weighing whether any federal app-specific legislation could survive litigation. Congress has considered bills that would limit access to and transmission of information through and to certain apps. Examples, some of which are analyzed in the Legal Sidebar Report, Restricting TikTok Part 2 Legislative Proposals and Considerations for Congress, include the Government Off TikTok Act, House Bill 5144, the ACES Act of 2023, House Bill 4927, the No TikTok on American Devices Act, House Bill 503/Senate Bill 85, the Protecting Personal Data from Foreign Adversaries Act, House Bill 57, the Data Act, House Bill 1153, the Restrict Act, Senate Bill 686, the Antisocial CCP Act, House Bill 1081/Senate Bill 347, and the Safety on Social Media Act of 2023, Senate Bill 872. While federal legislation does not face preemption or dormant Commerce Clause hurdles, some of the remaining constitutional questions posed by Montana State Bill 419 may be litigated if bills seeking to regulate TikTok and other social media sites become federal law. The contours of the constitutional analysis could vary, however, given differences in the federal proposals. The final results of the legal challenges to Montana State Bill 419 may further define the scope of the federal and state remit to legislate in ways that restrict foreign-owned apps or platforms. End of Section 4. Read by Elsie Selwyn. Section 5 of TikTok Collected Reports by Various. This LibriVox recording is in the public domain. House Bill 7521 Regulation of TikTok. Analysis of selected legal issues by Peter J. Benson, Valerie C. Brannon, and Joanna R. Lampe. Released March 20th, 2024. On March 13th, 2024, the House of Representatives passed the Protecting Americans from Foreign Adversary Controlled Applications Act, House Bill 7521. If enacted, House Bill 7521 would make it unlawful to provide certain services to, quote, distribute, maintain, or update a foreign adversary-controlled application, end quote, within the United States. The bill expressly includes applications operated by TikTok or its parent company ByteDance Limited in the definition of, quote, foreign adversary-controlled application, end quote. This legal sidebar summarizes the substantive provisions in House Bill 7521, analyzes the bill's provisions related to enforcement and judicial review, and addresses potential constitutional considerations related to the bill, focusing on questions that have been raised regarding application of the Bill of Attainder Clause and the First Amendment's Free Speech Clause. Other Congressional Research Service products discuss policy considerations with House Bill 7521, address other legal considerations raised by proposals to restrict TikTok, and provide more information on the technology used by TikTok. Overview of House Bill 7521. On March 7, 2024, the House Committee on Energy and Commerce held a hearing titled Legislation to Protect American Data and National Security from Foreign Adversaries, and voted unanimously to advance the two bills discussed at the hearing. Both bills, House Bill 7521 and the Protecting Americans' Data from Foreign Adversaries Act of 2024, House Bill 7520, were favorably reported to the House without amendment. House Bill 7521 then passed the full House less than 1 week later, on March 13, 2024. House Bill 7520 subsequently passed the House on March 20th. House Bill 7521 would regulate, quote, foreign adversary-controlled applications, end quote, and the app stores and internet hosting services through which users access them. The bill expressly defines a foreign adversary-controlled application to include applications operated by TikTok and any other subsidiary of TikTok's parent company ByteDance Limited. The definition also includes any other website, app, or augmented or immersive technology that 1. Meets certain definitional requirements, such as allows users to share content with each other and has more than 1 million monthly active users. 2. Is owned by a company located in, or a company for which persons owning at least a 20% stake are located in, a foreign adversary-controlled country listed in Volume 10 of the United States Code, Section 4872 D2, and 3. Has been determined by the President to present a significant national security threat. The bill excludes applications from these definitional requirements if the, quote, primary purpose, end quote, of the application, quote, is to allow users to post product reviews, business reviews, or travel information in reviews. Under the bill, app stores and internet hosting services would be prohibited from enabling the distribution, maintenance, or updating of foreign adversary-controlled applications. This prohibition would take effect 180 days after the date of enactment for TikTok and other applications operated by ByteDance or its subsidiaries. If the President were to determine that another application qualified as a foreign adversary-controlled application, the prohibition would take effect with respect to such application 180 days after the applicable presidential determination. During the 180-day period between designation as a foreign adversary-controlled application and the effective date of the prohibition, a foreign adversary-controlled application would be required to provide U.S. users, upon request, with all the data related to their accounts, including their posts, photos, and videos in a machine-readable format. Foreign adversary-controlled applications, app stores, and internet hosting services would face civil penalties if they do not comply with these provisions. An app store or internet hosting service that continues to enable distribution, maintenance, or updates for a banned application could be subject to civil penalties of up to $5,000, multiplied by the number of U.S. users who accessed, maintained, or updated the application. A foreign adversary-controlled application that fails to provide user data as required could be subject to civil penalties of up to $500 multiplied by the number of affected users. House Bill 7521's restrictions would not apply to TikTok or any other foreign adversary-controlled application if the application completes a, quote, qualified divestiture, end quote. For a divestiture to qualify, the President would have to determine that application is no longer controlled by, and has no operational relationship with, a foreign adversary. Because the prohibition on app stores and internet hosting services enabling the distribution, maintenance, or updating of foreign adversary-controlled applications would not take effect for 180 days, from the date of enactment for applications operated by TikTok or ByteDance, or from the date of the relevant presidential determination for other applications, a qualified divestiture completed within this 180-day period would prevent the prohibition from taking effect. Even after the end of the 180-day period, House Bill 7521's restrictions would cease to apply once a qualified divestiture has been completed. Enforcement and judicial review. Section 2D of House Bill 7521 governs enforcement of the Act. Section 2D1 would impose civil penalties on entities who violate the Act's prohibitions. Section 2D2 would provide for enforcement by the Attorney General. Specifically, Section 2D2A authorizes the Attorney General to investigate potential violations and provides that, quote, if such an investigation results in a determination that a violation has occurred, the Attorney General shall pursue enforcement under paragraph 1, end quote. Section 2D2B authorizes the Attorney General, upon determination that a violation has occurred, to, quote, bring an action in an appropriate district court of the United States for appropriate relief, including civil penalties under paragraph 1, or declaratory and injunctive relief, end quote. Section 2D2B would authorize the Attorney General to sue in federal district court to sanction and remedy violations of House Bill 7521. It is not clear whether the directive in Section 2D2A that the Attorney General, quote, shall pursue enforcement under paragraph 1, end quote, seeks to provide for enforcement other than via civil suits under Section 2D2B. To the extent Section 2D2A seeks to authorize enforcement through other means, such as administrative procedures, the bill does not clearly specify what would be authorized. Section 3 of House Bill 7521 would limit judicial review of the Act itself, or any enforcement actions taken pursuant to the Act. Section 3A provides, quote, a petition for review challenging this Act or any action, finding, or determination under this Act may be filed only in the United States Court of Appeals for the District of Columbia Circuit, end quote. The term, quote, petition for review, end quote, is generally used in other statutes to refer to judicial review of agency action. Because it is not clear whether and to what extent House Bill 7521 authorizes administrative enforcement or other agency actions apart from civil suits, there may be uncertainty about what this provision includes. To the extent Section 2D2A of the Act would authorize administrative enforcement, Section 3A would require petitions for review of such agency action to proceed in the D.C. Circuit. Section 3B provides that the D.C. Circuit, quote, shall have exclusive jurisdiction over any challenge to this Act or any action, finding, or determination under this Act, end quote. If House Bill 7521 were enacted, constitutional challenges to the Act could potentially arise in two ways other than via petitions for review of agency action. First, regulated entities or others alleging imminent harm under the Act could sue to prevent enforcement of the Act. This would take the form of a pre-enforcement or offensive challenge to the Act seeking to enjoin, in other words prevent, the Attorney General from enforcing the Act. A challenge to a presidential determination under the Act might also proceed in this posture. Under current law, a pre-enforcement challenge to a federal law is generally brought by filing a civil action in a trial-level federal district court. However, because Section 3B grants the D.C. Circuit exclusive jurisdiction over challenges to the Act or to actions or determinations under the Act, it appears that such challenges would need to proceed in the D.C. Circuit. Second, if the Attorney General sued a person for violating the Act, the defendant might raise a constitutional claim as a defense to liability, which is sometimes called a defensive challenge. A defensive challenge is ordinarily raised in response to a suit in the court where the case was commenced. Section 2D2B authorizes the Attorney General to bring enforcement suits in federal district court. So, absent special rule sending litigation to a different court, a defensive constitutional challenge to the Act would generally proceed in the same case in the same district court. However, under Section 3B, it appears that such challenges would need to proceed in the D.C. Circuit. This could mean that cases the Attorney General filed in district court would need to be transferred or otherwise referred to the D.C. Circuit if the defendant raised a constitutional defense. House Bill 7521 does not expressly provide for such transfer or referral, leaving some uncertainty about how a defensive challenge would proceed. As a constitutional matter, Congress has substantial authority to direct certain federal cases to specific federal courts, and some existing statutes require certain categories of case to proceed in the D.C. Circuit. Existing laws that route cases to the D.C. Circuit generally apply to appeals or to petitions for review of agency action, which sometimes begin in the Federal Appeals Court. Section 3A of the Act would be similar to these existing laws. By contrast, sending matters to the D.C. Circuit before they are considered by a trial court or an administrative agency would be unusual. Congress generally does not provide for lawsuits to commence in the Federal Appeals Court or to be transferred to a federal appellate court if a defendant raises a particular defense. statutes that direct certain cases to specific courts have been subject to significant litigation. Because Section 3 of House Bill 7521 appears to provide for novel treatment of some cases and does not clearly specify the applicable procedures, litigation around the Act's jurisdiction and venue provisions could occur if the bill became law. Such litigation would not be likely to cast doubt on the constitutionality of the Act, but could impose costs and delays in enforcement. Bill of Attainder Analysis of House Bill 7521. Article 1, Section 9, Clause 3 of the Constitution prohibits Congress from enacting bills of attainder, legislation that directly imposes punishment on an identifiable person or class of persons. Because House Bill 7521 applies to TikTok and ByteDance by name and imposes legal consequences that the companies find objectionable, there is some risk that, if enacted, the legislation might be challenged as a bill of attainder. However, there are several reasons why courts may be unlikely to strike down the legislation on that ground. In the leading bill of attainder case, Nixon v. Administrator of General Services, the Supreme Court held that legislation constitutes a bill of attainder if it 1. Applies with specificity, and 2. Imposes punishment, 3. Without a judicial trial. All three requirements must be satisfied before a court will strike down a law as a bill of attainder. With respect to specificity as a technical matter, the civil penalties in House Bill 7521 would not apply only to the named companies. The President could determine that additional applications qualify as foreign adversary-controlled applications, and the civil penalties provided in the bill could apply both to companies that operate any foreign adversary-controlled application and entities that enable the distribution or maintenance of the applications. The bill does name TikTok and ByteDance and would impose a burden on the named companies, however, essentially requiring a qualified divestiture within 180 days to allow app stores to continue lawfully providing applications operated by those companies to U.S. users. The court could therefore find that the legislation satisfied the specificity requirement. Importantly, however, specificity standing alone is never sufficient to support a finding that a law is a bill of attainder. The law must also impose punishment without trial. The determination of whether a law imposes punishment is complex and fact-based. The Congressional Research Service In Focus report, Sanctions Legislation in the Bill of Attainder Clause, provides analysis of how courts might apply the relevant legal standards to international sanctions legislation. House Bill 7521 is not sanctions legislation, but much of that analysis would also apply to the current bill. As a general matter, review of whether legislation is punitive for purposes of the Bill of Attainder Clause is deferential, and federal courts rarely strike down laws as bills of attainder. Courts are more likely to strike down legislation as a bill of attainder if it imposes punishment resembling criminal penalties, based on a determination that the targeted entity has engaged in culpable conduct in the past. Courts are less likely to strike down legislation that reasonably serves a non-punitive, forward-looking legislative purpose. To the extent a court determined that House Bill 7521 was intended to protect national security, rather than punishing the named companies, it would likely find that the legislation did not impose punishments for purposes of the Bill of Attainder Clause. Finally, the Bill of Attainder Clause bans only laws that impose punishment without trial. Section 2D2B of House Bill 7521 would authorize the Attorney General to sue in district court to enforce the Act, thus providing a judicial trial before any sanction would be imposed. To the extent House Bill 7521 would also authorize administrative enforcement, multiple federal appeals courts have held that the Bill of Attainder Clause does not apply to executive agency action. Moreover, it appears that any administrative enforcement action could be subject to judicial review by the D.C. Circuit. If a court found that House Bill 7521 did not directly impose any legal liability without trial or agency enforcement action, it would not strike down the legislation as a bill of attainder. First Amendment considerations with House Bill 7521. Some civil rights groups, trade groups, and others have asserted that House Bill 7521 could infringe the First Amendment rights of TikTok, hosting services, and users. Similar claims were made with respect to the Trump administration's restrictions on TikTok and WeChat, and with state laws restricting TikTok, as discussed in a prior legal sidebar. Ongoing litigation over a Montana law barring TikTok from operating in the state is discussed in more depth in a separate legal sidebar, although some of the legal issues raised in that case are specific to the state law context. In cases challenging these restrictions in court, users argued the government violated the First Amendment by barring them from accessing an important forum for speech. TikTok claimed bans on the platform affect its own speech, in part by citing constitutional protections for speech hosts, a doctrine at issue in 2 cases currently pending before the Supreme Court. In other cases, TikTok also challenged bans as prior restraints, a distinct First Amendment doctrine raising additional constitutional considerations. App stores and other sites have alleged similar constitutional privileges to curate and display content. Some members of Congress and government officials have defended House Bill 7521's constitutionality by arguing the bill regulates conduct rather than targeting the content of speech. The First Amendment prevents the government from unduly infringing expressive activity, whether so-called pure speech or expressive conduct, but does not bar the government from regulating conduct without any expressive element. First Amendment protections are triggered if a law targets conduct with both expressive and non-expressive elements, or has the inevitable effect of targeting expressive activity. With respect to House Bill 7521, some have argued that the bill focuses on national security threats and an application's ownership by a foreign adversary, characterized as non-expressive conduct of covered platforms. On the other hand, because the bill specifically identifies TikTok and could allow the president to designate other websites or applications that serve as platforms for speech, it could be seen as, quote, singling out those engaged in expressive activity, end quote, and trigger First Amendment scrutiny. A federal trial court, for instance, ruled that a Montana law prohibiting TikTok's operations in the state targeted expressive activity, not solely non-expressive conduct, because it banned a means of expression. Another argument that House Bill 7521 might not burden speech could stem from the bill's posture as a forced divestiture rather than a ban. Specifically, some have pointed out that House Bill 7521's prohibitions only apply if TikTok does not execute a, quote, qualified divestiture, end quote, suggesting that the company can continue to operate, quote, so long as it resolves the national security risks posed by its ownership structure, end quote. Depending on whether and how a divestiture occurs, users might still be able to access the platform to share and receive speech, and app stores and hosting services might still be able to host the platform. The divestiture requirement could seemingly still burden TikTok's ability to operate a platform for speech, however, and the Supreme Court has recognized that even arguably economic regulations or restrictions short of a complete ban can burden speech in ways that potentially trigger some form of heightened judicial scrutiny. If House Bill 7521 were considered to burden expressive activity, the next relevant question in a constitutional analysis would be what level of First Amendment scrutiny should apply. Courts apply various tests, depending on what type of speech is being regulated and how a given law operates. One important factor in this inquiry is whether a law is content-based or content-neutral. That is, whether a law applies to expression based on its subject matter, topic, or viewpoint. A content-based law will ordinarily be subject to strict scrutiny analysis and considered presumptively unconstitutional. Under strict scrutiny, a law is valid only if it is the least restrictive means to serve a compelling government interest. Restrictions based on the identity of the speaker may also be constitutionally suspect, particularly if the speaker is targeted because of their disfavored speech. Accordingly, if there were evidence House Bill 7521 is targeting specific companies because of their speech or viewpoint, it might be evaluated under strict scrutiny and more likely to be ruled unconstitutional. The bill's definition of covered companies might be relevant to this inquiry. The bill excludes companies with the primary purpose of allowing users to post certain product, business, or travel reviews, arguably excluding these businesses based on the subject matter or topic of the speech they host. Lower courts that have evaluated state laws regulating social media companies have described somewhat similar exclusions in those laws as content-based. If indeed a law is considered content neutral, or if it only incidentally restricts speech while targeting non-expressive activity, it may be reviewed under intermediate scrutiny. Under this constitutional standard, a law will be upheld if it advances a, quote, important or substantial, end quote, government interest unrelated to the suppression of speech, if the restriction on speech is, quote, no greater than is essential, end quote, to further this interest, and if it leaves open, quote, ample alternative channels for communication of the information, end quote. Even if a reviewing court rejected the argument that House Bill 7521 regulates non-expressive conduct, it might still consider whether the legislation could be justified as a content-neutral ban on a particular manner of communicating, that is, on communicating via covered sites. Intermediate scrutiny is an easier standard for the government to satisfy than strict scrutiny, but still entails a relatively robust standard of review. Courts have recognized that the federal government has a significant interest in national security, for instance, but trial courts evaluating bans on WeChat and TikTok have nonetheless concluded that the government did not meet the other prongs of the intermediate scrutiny standard. In particular, a court might evaluate whether the federal government could achieve its national security interests through an approach that is less speech restrictive than a complete ban on the platform or a requirement to divest. It might also consider whether other speech platforms provide adequate alternatives for users to speak. End of Section 5, read by Elsie Selwyn. Section 6 of TikTok, Collected Reports, by Various. This LibriVox recording is in the public domain. TikTok, Frequently Asked Questions and Issues for Congress by Michael D. Sutherland, Peter J. Benson, and Kristen E. Bush. Released April 9, 2024. Part 1. Summary. Since 2018, the social media application TikTok, developed and owned by ByteDance Limited, ByteDance, has become one of the most popular social media platforms in the United States and raised oversight and legislative issues for Congress. With short-form video format and sophisticated content recommendation algorithms and usability design, TikTok achieves significant market penetration in the United States amid competition with other social media platforms such as Meta, formerly Facebook, Instagram, X, formerly Twitter, and Snapchat. TikTok's short-form video application was initially developed by Musical.ly, a company founded in the People's Republic of China, PRC or China, but primarily operating in the United States. In 2018, Musical.ly was acquired by ByteDance, a firm incorporated in Cayman Islands with headquarters in Beijing, China, and relaunched as TikTok, operated by TikTok Limited, also incorporated in the Cayman Islands, and headquartered in Los Angeles and Singapore. TikTok Limited is owned by ByteDance Limited. TikTok is not available in China. Since its launch in the United States, some policymakers, technical experts, and members of Congress have expressed concerns regarding TikTok's ownership structure and potential implications for U.S. national security and the data privacy and security of U.S. users. Some members have argued that ByteDance, a People's Republic of China headquartered company, is subject to potential People's Republic of China government pressure through various People's Republic of China laws and regulations governing intelligence, cybersecurity, and data security. They argue that the People's Republic of China government could apply these laws and regulations to compel ByteDance to turn over U.S. user data. Some members have contended that the People's Republic of China government could potentially use TikTok as a platform for influencing public opinion in the United States, or conducting malign activities such as spreading misinformation or interfering in elections. Some members have also expressed broader concerns related to TikTok's content moderation and online safety policies, particularly those that govern online protection for minors. Proponents of TikTok emphasize its role as a platform for accessing information, sharing content, generating revenue for small businesses and entrepreneurs, as well as its relatively similar data and content moderation practices compared to other social media competitors. To date, both the executive branch and Congress have taken actions to address concerns about TikTok's ownership structure and implications for national security and data privacy. In 2020, the Trump administration issued orders that would, among other things, prohibit U.S. entities from conducting transactions with TikTok and require TikTok's parent company ByteDance to divest from TikTok. TikTok challenged these actions in court. In January 2021, the Biden administration rescinded some of the Trump administration's actions and issued new executive actions to address the broader national security implications of the People's Republic of China social media platforms in the United States. In the 118th Congress, members have introduced legislation to build on and expand existing executive authorities and actions taken against TikTok, such as Senate Bill 686, the Restricting the Emergence of Security Threats that Risk Information and Communications Technology Act, RESTRICT Act, which was introduced in the Senate, and House Bill 7521, the Protecting Americans from Foreign Adversary-Controlled Applications Act, which passed the House on March 13, 2024. This report compiles responses to frequently asked questions, FAQs, regarding TikTok, its ownership, and the corporate structure of ByteDance Limited, and potential national security and data privacy concerns related to the platform. This report also summarizes past executive action and legislation that sought to address these concerns, and examines potential constitutional considerations and policy implications for legislation and oversight that Congress could consider related to TikTok. Background. This report compiles frequently asked questions, FAQs, regarding TikTok, its ownership, and the corporate structure of ByteDance Limited and potential national security and data privacy concerns related to the platform. This report also summarizes past executive action and legislation that sought to address these concerns, and examines potential constitutional considerations and policy implications for legislation and oversight that Congress could consider related to TikTok. TikTok's functionality, users, and business operations. What is TikTok? TikTok is a social media application, one of the most popular social media platforms in the United States, that allows users to easily generate, post, and share short-form videos, typically ranging from 15 to 60 seconds in length. TikTok selects and displays videos for individual users based on their user interactions, likes, shares, and comments, video metadata, hashtags, captions, and sounds, and the device and account settings, language preference, device type, etc. TikTok is owned by TikTok Limited, a subsidiary of ByteDance Limited, hereinafter referred to as ByteDance, and is the global counterpart to Douyin, ByteDance's short-form video application that the company launched for users in China in 2016. TikTok and Douyin share certain core features, though they reportedly use separate algorithms tailored to promote content to their respective audiences. How many users does TikTok claim to currently have? According to TikTok's estimates, as of March 2024, its user base has more than 170 million monthly active users in the United States and 7 million businesses that market or advertise on the platform. In 2021, TikTok announced that it had surpassed more than 1 billion monthly active users across the world. According to the Pew Research Center, TikTok, quote, stands out for growth of its user base, end quote, among U.S. adults, with 33% of adults reporting using it in 2023, up 12% from 2021. How did TikTok become so popular? Some experts attribute the rapid growth of TikTok's user base in the United States in part to the ByteDance 2018 acquisition of competitor Musical.ly, which had an estimated base of approximately 100,000 U.S. monthly active users at the time of the acquisition. In August 2018, ByteDance officially rebranded the Musical.ly app as TikTok and migrated Musical.ly users to new TikTok accounts. A key feature of TikTok's service is the company's recommendation algorithm, which is a system that sorts, curates, and disseminates content deemed relevant to specific users. Who owns TikTok? TikTok Limited, a holding company incorporated in the Caribbean overseas British territory of Cayman Islands, directly owns TikTok. ByteDance Limited, a holding company incorporated in the Cayman Islands and with core business operations and leadership located in China, directly owns TikTok Limited. TikTok Limited lists its global headquarters as Los Angeles and Singapore. Its chief executive officer, CEO, Shou Zi Chu, a citizen of Singapore, operates out of both headquarters, according to statements Chu made to a U.S. media outlet in February 2024. Who owns ByteDance, and where is it located? ByteDance is incorporated in the Cayman Islands. The company has listed its operational headquarters and primary place of business as Beijing, China. Footnote: leadership and management position vacancies currently listed at ByteDance appear to be based in the company's Beijing, Shanghai, and Hong Kong offices. End footnote. Some legal experts also note that the majority of granted patents related to ByteDance's core software applications are registered in China and held by Beijing Douyin Information Services Company Limited, a subsidiary of ByteDance that houses ByteDance's key personnel, infrastructure, and conducts the firm's operations in China. In March 2023, testimony before the House Energy and Commerce Committee, TikTok CEO Shou Zichu, when asked whether ByteDance is a People's Republic of China company, said, quote, ByteDance owns many businesses that operate in China, end quote, and, quote, was founded by Chinese entrepreneurs, end quote. In January 2024, testimony before the Senate Judiciary Committee, Shou stated that, quote, ByteDance is a global company and not a Chinese company, end quote. What is ByteDance's relationship to the People's Republic of China, PRC? ByteDance is a privately held company, and details on its global operations and ultimate shareholding structure is not widely available beyond information published by ByteDance. Several experts and policymakers consider ByteDance to be ultimately subject to the jurisdiction of the People's Republic of China. In its official corporate structure, ByteDance currently lists all of its global subsidiaries and offices, including its original People's Republic of China-based firm Beijing ByteDance Technology Company Limited, Beijing ByteDance, as subsidiaries of ByteDance Limited in the Cayman Islands. In February 2023, ByteDance published an updated corporate structure in which it renamed Beijing ByteDance as Beijing Douyin Information Services Company Limited, Beijing Douyin. ByteDance uses a variable interest entity (VIE) structure. China prohibits foreign investors from investing in China's internet and telecommunications companies, among other types of companies. To access international capital under these restrictions, firms in China's technology sectors, including ByteDance, frequently use a variable interest entity structure. This structure relies on an offshore holding company tied through a series of contracts to the People's Republic of China firm, which holds the core assets and conducts the firm's global business. Overseas investors invest in the offshore entity, commonly a holding company incorporated in a jurisdiction such as the Cayman Islands or British Virgin Islands, and receive a share of the firm's revenue without making any direct equity investment in the core assets of the business. Is TikTok available in China? Internet users in China are not able to easily access TikTok. They are able to access Douyin, TikTok's predecessor turned companion application. U.S. and multinational digital platforms, including TikTok, are unable to operate legally in China due to restrictions on foreign investment and operations in various technology sectors. National security and data privacy concerns. Is ByteDance a People's Republic of China company? ByteDance's executives have maintained that ByteDance's incorporation in the Cayman Islands means that it should not be considered a People's Republic of China company. People's Republic of China officials have referred to ByteDance as a People's Republic of China company and have cited the company's obligations to comply with the People's Republic of China data security and export control regulations as factors that may impede or block a ByteDance divestment from TikTok. Some experts contend that the People's Republic of China government controls ByteDance, or at least exerts a degree of influence over ByteDance, through a 2021 investment in Beijing Douyin Information Services Company Limited, Beijing Douyin, the entity that owns TikTok's core technology, by Wang Touzhongwen, Beijing Technology. The company financed its stake in ByteDance with funding from the Chinese Internet Investment Fund, CIIF, a People's Republic of China government-run investment fund capitalized by joint capital contributions from the Cyberspace Administration of China, CAC, and China's Ministry of Finance. Through this investment, Wang Touzhongwen and the China Internet Investment Fund, by extension, acquired a 1% stake in Beijing Douyin and a seat on the firm's board. Some experts describe this 1% share as a golden share, a reference to the People's Republic of China government's strategy of making small targeted investments that, in the view of these experts, gives the People's Republic of China government visibility, influence, and control over the decisions and operations of certain strategic firms in China's private sector. Following this acquisition in December 2021, Cyberspace Administration of China official Wu Shugang was appointed to Beijing Douyin's Board of Directors. Does the government of the People's Republic of China exercise control over ByteDance? The People's Republic of China government has tools that it may use to exert control over ByteDance, and potentially by extension TikTok, and other People's Republic of China digital platform developers. These tools may include, for example, Communist Party of China party organizations. Since 1993, the People's Republic of China government has required companies in China's private sector that employ 3 or more party members to establish internal party organizations. Since becoming the Communist Party of China General Secretary in 2013, Xi Jinping has taken action to expand the role and influence of party organizations inside the People's Republic of China firms, including in the selection of executives in larger People's Republic of China companies. Official content guidelines and censorship rules. The People's Republic of China government maintains a robust online censorship regime that it uses to shape the content published to China's social media platforms. Some observers have cited instances of content suppression and promotion that TikTok and ByteDance representatives later acknowledged. Footnote: in September 2019, a review of TikTok internal guidelines published by The Guardian revealed that TikTok had been suppressing the visibility of, and in some cases removing, content that could be seen as portraying LGBTQ+ individuals or their lifestyles positively, alongside content that was deemed politically sensitive to Beijing. TikTok later stated that it had also been suppressing the visibility of content that portrayed individuals that were overweight or displayed conspicuous disabilities, noting that elements of the policy were adopted to comply with broader ByteDance content moderation policies, and that those policies had been replaced with localized content moderation guidelines. In 2020, TikTok released an apology message for a, quote, technical glitch, end quote, that made it, quote, temporarily appear as if posts uploading hashtag Black Lives Matter and hashtag George Floyd would receive 0 views, end quote. End footnote. Data security, export controls, and cybersecurity regulations. The People's Republic of China government has applied existing cybersecurity and data security laws to influence corporate activity in China. The People's Republic of China officials have indicated that they could apply China's export control laws to block ByteDance from divesting TikTok, stating that social media algorithms developed by the People's Republic of China firms fall under China's export control regulations. What laws and regulations in China could influence ByteDance operations? Since 2015, the People's Republic of China government and the Communist Party of China have adopted interrelated laws, economic security measures, and data restrictions that enhance their control over data and commercial activity within and outside of China, which could influence ByteDance operations. They have expanded data localization requirements, placed data under export controls, and, since 2021, required security reviews for People's Republic of China firms listing or operating overseas. Some People's Republic of China provisions require firms to adhere to the People's Republic of China requirements, even when those requirements conflict with U.S. laws. Relevant laws in China include, for example, the People's Republic of China National Security Law 2015 requires information systems in China to be, quote, secure and controllable, end quote. Since 2016, the People's Republic of China government has required U.S. technology firms to store data and cryptographic keys in China. The People's Republic of China National Cybersecurity Law 2017 requires firms to store personal information and data within China, and it underpins requirements to place the People's Republic of China data and related infrastructure in China. The People's Republic of China Data Security Law 2021 covers data processing inside and outside of China if it, quote, harms the national security, public interest, or the legitimate rights and interests of citizens or organizations of the People's Republic of China." End quote. The law requires People's Republic of China government approval for the transfer of data stored in China, and calls for classifying data according to its importance in China's economic development and national security interests. In August 2020, the People's Republic of China added algorithms used in social media platforms to China's catalog of technologies prohibited and restricted from export, which is regularly updated according to China's Export Control Law 2020. The addition followed the Trump administration's announcement earlier in August 2020 of executive actions targeting People's Republic of China's social media applications, including TikTok. Does ByteDance share user data with the government of the People's Republic of China? TikTok has denied that it shares data with the People's Republic of China government or the Communist Party of China. In its responses to questions for the record following TikTok CEO Shou Zi-Chew's testimony in March 2023 before the House Energy and Commerce Committee, TikTok provided a response indicating that the company, quote, has never shared or received a request to share U.S. user data with the Chinese government, end quote. In response to questions for the record about ByteDance and its adherence to the People's Republic of China government policies, TikTok provided a response indicating that, quote, ByteDance's products follow the local laws and regulations of the countries they operate in, end quote. Neither TikTok nor ByteDance have issued a statement to date on whether ByteDance or any of its subsidiaries in China have received requests to share data from the People's Republic of China government. One former ByteDance executive reportedly has alleged that ByteDance did share certain user data with the company's internal Communist Party of China committee. Footnote: in June 2023, a former ByteDance executive who was engaged in litigation against the company claimed that ByteDance's internal Communist Party of China committee was granted access to data of users based in Hong Kong in 2018. The former executive claimed that this access was to facilitate efforts to pressure ByteDance internally to support the People's Republic of China government's efforts at the time to crack down on Hong Kong's pro-democracy movement. ByteDance denies the claim. End footnote. Where does TikTok store user data? TikTok provided a response to questions for the record following CEO Shou Zi-Chew's March 2023 testimony before the House Energy and Commerce Committee, indicating that at least 7 years' worth of U.S. users' TikTok data, specifically data related to paid content creators, is stored in data centers located in China. As part of its efforts related to Project Texas, an initiative started by TikTok that it has claimed would address U.S. government security concerns, TikTok issued a statement indicating that it is, quote, committed to storing all U.S. user data in the United States, end quote, in cooperation with Oracle and other U.S. firms. See what is Project Texas. TikTok also has issued statements claiming that, quote, as of July 2022, all new U.S. user data is stored automatically in Oracle's U.S. cloud infrastructure, and access is managed exclusively by the TikTok U.S. data security team, end quote. Some experts contend that whether and where TikTok stores data could potentially be unrelated to the Chinese government's ability to access TikTok's data. As reported in 2020, there appears to be incidences of ByteDance employees located in China remotely accessing U.S. TikTok user data from ByteDance offices in Beijing in support of Project Texas. The U.S.-based company Oracle currently provides cloud infrastructure for TikTok. According to TikTok, quote, 100% of U.S. user traffic is being routed to Oracle Cloud infrastructure, end quote, and U.S. and Singapore data centers are used as backup. How does TikTok moderate content and recommend content? TikTok has maintained that its content moderation policies and recommendation algorithms operate independently of ByteDance and its other products, and that TikTok tailors these policies and recommendation algorithms to be compliant with the laws of each country where it operates, and also to promote content specific to each country where it operates. In its responses to questions for the record following TikTok CEO Shou Zi-Chew's March 2023 testimony before the House Energy and Commerce Committee, TikTok indicated that it promotes certain content, but claimed that it does not do so at the request of any government. Some observers have cited instances of content suppression and promotion that TikTok and ByteDance representatives later acknowledged. End of Section 6, read by Elsie Selwyn. Section 7 of TikTok, Collected Reports by Various. This LibriVox recording is in the public domain. TikTok, Frequently Asked Questions and Issues for Congress by Michael D. Sutherland, Peter J. Benson, and Kristen E. Bush. Released April 9, 2024. Part 2. Efforts to regulate TikTok. What actions has the executive branch taken to address alleged national security risks TikTok poses? With regard to ByteDance and TikTok, the executive branch has sought to address identified national security concerns related to the firm's presence and operations in the United States using two separate authorities and legal frameworks. 1. The Committee on Foreign Investment in the United States, CFIUS, and 2. The International Emergency Economic Powers Act, IEEPA. These two actions are discussed in the questions that immediately follow. What are the details of the Committee on Foreign Investment in the United States investigation of the ByteDance acquisition of Musical.ly? In 2019, the Committee on Foreign Investment in the United States conducted a retroactive national security review and investigation of the ByteDance completed acquisition of Musical.ly, which had originally not been submitted by the parties for the Committee on Foreign Investment in the United States review. Footnote. The Committee on Foreign Investment in the United States is an interagency committee chaired by the Secretary of the Treasury. It serves the President in overseeing the national security risks of certain foreign direct investment (FDI) in the U.S. economy. End footnote. Following its investigation, the Committee on Foreign Investment in the United States referred the transaction to President Trump for a presidential decision. The presidential decision, issued on March 2020, concluded that the acquisition threatened U.S. national security. In referring the case to the President, the Committee on Foreign Investment in the United States signaled it could not mitigate the identified national security risks arising from the transaction. The Committee on Foreign Investment in the United States does not publicly comment on investigations or mitigation negotiations, including with respect to TikTok. What actions followed the 2019 Committee on Foreign Investment in the United States investigation of the ByteDance acquisition of Musical.ly? In August 2020, President Trump concluded that the ByteDance acquisition of Musical.ly threatened U.S. national security and issued a presidential order under the Committee on Foreign Investment in the United States' authorities, directing ByteDance to divest 1. Any asset or property used to enable or support the operation of TikTok in the United States, and 2. Data obtained or derived from TikTok or Musical.ly app users in the United States. In a statement issued following the order, then Treasury Secretary Steven Mnuchin said that, quote, the Committee on Foreign Investment in the United States conducted an exhaustive review of the case and unanimously recommended this action to the President in order to protect U.S. users from exploitation of their personal data, end quote. In November 2020, ByteDance and TikTok contested the order through a legal challenge, arguing, among other things, that the order was an unconstitutional taking of their private property without just compensation, and that it violated their due process rights under the Fifth Amendment. The case is currently held in abeyance at the request of both parties. The court directed the government to file status reports every 60 days, and the government has reported as directed. According to the February 2024 report, the parties continue to negotiate whether the litigation can be resolved by mutual agreement. What actions did the U.S. government take under International Emergency Economic Powers Act authorities? The International Emergency Economic Powers Act gives the President broad authority to block a variety of economic transactions following the declaration of a national emergency. Based on the national emergency declared in Executive Order 13,873 in May 2019, in August 2020, President Trump issued Executive Order 13,942, which exercised authority provided by the International Emergency Economic Powers Act to restrict TikTok's U.S. operations. The then Secretary of Commerce subsequently implemented this order by issuing a list of prohibited transactions, including maintaining TikTok on a mobile app store or providing internet hosting services to it. have the actions the U.S. government took under International Emergency Economic Powers Act authorities been challenged in court. 2 lawsuits were filed challenging Executive Order 13,942, one brought by TikTok and its parent company ByteDance, and the other brought by a group of TikTok users. The plaintiffs in these suits argued, among other things, that the president exceeded his authority under the International Emergency Economic Powers Act by regulating conduct that they contended falls under 2 statutory exceptions. First, under the personal communication exception, the president may not rely on the International Emergency Economic Powers Act to regulate or prohibit any, quote, personal communication which does not involve a transfer of anything of value, end quote. Second, under the informational materials exception, the president may not rely on the International Emergency Economic Powers Act to regulate or prohibit the importation or exportation of most, quote, informational materials, end quote. The plaintiffs argued that TikTok's core function, creating and sharing short-form videos, involved transmitting personal communications and informational materials, albeit in a modern format. In both suits, the court issued preliminary injunctions temporarily barring the United States from enforcing the restrictions. Footnote: in the case brought by TikTok and ByteDance, the court concluded that the plaintiffs were likely to prevail on the argument that the ban ran afoul of both relevant exceptions. In the TikTok user's case, the court limited its decision to the informational materials exception. End footnote. In June 2021, before the injunctions expired, the Biden administration rescinded Executive Order 13,942 and replaced it with a broader Executive Order 14,034. Executive Order 14,034 directs the Secretary of Commerce to create a program to identify and address the potential national security risks arising from foreign internet-based and software-tied operations in the United States. These could include apps that are operated by entities owned by, controlled by, or subject to the jurisdiction of the People's Republic of China or other countries the Secretary of Commerce has designated as, quote, foreign adversaries, end quote. What legislation has Congress introduced to regulate TikTok? In 2022, Congress enacted a law directing the Office of Management and Budget, OMB, to develop standards and guidelines that require executive agencies to remove TikTok from government computers and other government information technology. On February 27, 2023, the Office of Management and Budget issued implementation guidance, which included instructions and deadlines for removing TikTok from federal devices. Members of Congress have also introduced a number of bills that would regulate TikTok. Some bills would limit the application of the International Emergency Economic Powers Act exceptions when the president invokes the International Emergency Economic Powers Act to regulate TikTok. For example, the No TikTok on United States Devices Act would direct the president to exercise his authority under the International Emergency Economic Powers Act to prohibit transactions involving ByteDance's property and would provide that the exceptions to the International Emergency Economic Powers Act, which courts relied on to preliminary enjoin an earlier exercise of the International Emergency Economic Powers Act authority to regulate TikTok, would not apply to the exercise of the president's authority pursuant to the bill. Other legislative proposals would create new administrative authorities that could be used to regulate TikTok. An example is the Safety on Social Media Act of 2023. That bill would direct the president to publish a list of, quote, untrustworthy applications and social media entities, end quote, and would direct the Federal Communications Commission to issue rules that prohibit app stores and internet service providers from supporting the listed applications. Proposals to expand data privacy frameworks or to create new restrictions on cross-border transfers of data could also regulate TikTok's, as well as other entities, collection, use, and transfer of data. On March 13, 2024, the House passed the Protecting Americans from Foreign Adversary-Controlled Applications Act, House Bill 7521, which expressly names TikTok as a, quote, foreign adversary-controlled application, end quote, subject to its provisions. House Bill 7521 would prohibit app stores and internet hosting services from supporting TikTok and other foreign adversary-controlled applications in the United States, unless their owners execute a, quote, qualified divestiture, end quote. What are the main elements of House Bill 7521, the Protecting Americans from Foreign Adversary-Controlled Applications Act? House Bill 7521, as passed by the House, would regulate, quote, foreign adversary-controlled applications, end quote, in the app stores and internet hosting services through which users access the applications. The bill's definition of foreign adversary-controlled application includes two categories of applications. First, applications operated by TikTok, ByteDance, or a subsidiary or successor of either company that is controlled by a foreign adversary qualify as foreign adversary-controlled applications. In addition to TikTok and applications operated by TikTok's parent company, ByteDance, this definition would capture applications operated by Beijing Douyin Information Services Company Limited, ByteDance's core operating subsidiary in China in which the Chinese government holds an equity stake. Second, the President may designate an application as a foreign adversary-controlled application if 1. The application allows users to share and view text, images, videos, or similar content, has more than 1 million monthly active users, and meets related definitional requirements. Footnote: if the primary purpose of the application, quote, is to allow users to post product reviews, business reviews, or travel information and reviews, end quote, it does not meet the definitional requirements. End footnote. 2. The application is operated by a person domiciled in, headquartered in, maintaining a principal place of business in, or organized under the laws of a, quote, foreign adversary country, end quote, defined to include the countries listed in Volume 10 United States Code, Section 4872 D2, or is operated by a company for which persons owning at least a 20% stake are domiciled in, headquartered in, maintaining a principal place of business in, or organized under the laws of a foreign adversary country. And 3. The President determines that the application presents a significant national security threat. Beginning 180 days after an application is designated as a foreign adversary-controlled application, House Bill 7521 would prohibit app stores and internet hosting services from enabling the distribution, maintenance, or updating of the application for U.S. users. Before the ban on app stores and internet hosting services supporting the application takes effect, the owner of a foreign adversary-controlled application would be required to provide U.S. users, upon request, with all data related to their accounts, including posts, photos, and videos in a machine-readable format. App stores and internet hosting services would not be prohibited from enabling the distribution, maintenance, or updating of TikTok or another foreign adversary-controlled application if the application's owners execute a, quote, qualified divestiture, end quote. House Bill 7521 defines qualified divestiture as a divestiture or similar transaction for which the President, through an interagency process, has determined that the application will no longer be controlled by a foreign adversary and will no longer have any operational relationship with entities controlled by a foreign adversary. A qualified divestiture that is completed within 180 days of an application being designated a foreign adversary-controlled application would allow app stores and internet hosting services to continue distributing, maintaining, and updating the application without interruption. Regardless of when a qualified divestiture takes place, House Bill 7521's restrictions would cease to apply once a qualified divestiture had been completed. Who could be penalized under House Bill 7521, and what penalties could be imposed? House Bill 7521, as passed by the House, would provide for civil penalties in two circumstances. First, if House Bill 7521 were enacted, an entity that violated the enacted law by providing a marketplace or internet hosting service that enabled distribution, maintenance, or updates of a foreign adversary-controlled application could be subject to civil penalties of up to $5,000, multiplied by the number of U.S. users who accessed, maintained, or updated the application. Second, if the bill were enacted, an entity that owned or controlled a foreign adversary-controlled application and violated House Bill 7521 by failing to provide machine-readable user data in response to requests from U.S. users, could be subject to civil penalties of up to $500 multiplied by the number of affected users. Would House Bill 7521 force any ByteDance or TikTok owners to divest from either company? House Bill 7521, as passed by the House, would not directly force ByteDance or TikTok owners to divest from either company. If House Bill 7521 were to be enacted, and ByteDance and TikTok owners were to elect not to execute a qualified divestiture, that election, in and of itself, would not constitute a violation of any provision in House Bill 7521. Nor would the election alone subject any party to the civil penalties provided in the bill. Under House Bill 7521, the primary consequence of a decision not to divest would be a prohibition on app stores and internet hosting services enabling access to TikTok in the United States, as opposed to an affirmative requirement to divest under penalty of legal liability. The combination of an election not to divest with additional conduct could subject ByteDance, TikTok, or other entities to civil penalties. If House Bill 7521 were to be enacted, ByteDance and TikTok owners were to elect not to execute a qualified divestiture, and TikTok were to fail to properly comply with requests for U.S. user data during the first 180 days after enactment, TikTok could be subject to civil penalties. After those 180 days, an entity that provides a marketplace for or internet hosting service that enables distribution, maintenance, or updates of TikTok for U.S. users could be subject to civil penalties. However, if TikTok were to properly comply with all user data requests, and if all app stores and internet hosting services serving U.S. users were to stop supporting TikTok, no party would be subject to House Bill 7521's civil penalties simply because of the lack of divestiture. If enacted, how could House Bill 7521 be challenged in court? If House Bill 7521, as passed by the House, were enacted, there are several ways a challenge to the enacted law might proceed to federal court. First, to the extent House Bill 7521 would authorize the Attorney General to enforce the bill through administrative proceedings, an entity that was subject to such administrative proceedings could file a petition for review of the agency action in the U.S. Court of Appeals for the D.C. Circuit. Footnote: as discussed in the Congressional Research Service Legal Sidebar Report, House Bill 7521 Regulation of TikTok, Analysis of Selected Legal Issues, it is not clear whether and to what extent House Bill 7521 authorizes administrative enforcement or other agency actions apart from civil suits. End footnote. Second, if the Attorney General sued a person or entity for violating the Act, the defendant might raise a constitutional claim as a defense to liability, which is sometimes called a defensive challenge. Third, regulated entities or others alleging harm under the Act could sue to prevent enforcement of the Act. This might take the form of a pre-enforcement challenge, sometimes called an offensive challenge, to the Act seeking to bar the Attorney General from enforcing it. Parties seeking to bring pre-enforcement challenges would need to demonstrate standing to sue, including showing that they faced actual or imminent harm if the Act were enforced. House Bill 7521 provides that the D.C. Circuit, quote, shall have exclusive jurisdiction over any challenge to this Act or any action, finding, or determination under this Act, end quote. What actions have been taken at the state level to regulate TikTok? A number of states have prohibited the installation or use of TikTok on state-owned devices through executive actions, legislative enactments, or both. Some states have also adopted broader bans on installing applications or communication technologies provided by entities based in the People's Republic of China on state-owned devices. In May 2023, Montana enacted a law, Montana Senate Bill 419, that would prohibit TikTok from, quote, operated within the territorial jurisdiction of Montana, end quote. Montana Senate Bill 419 provides that its effective date is January 1, 2024, but on November 30, 2023, a federal court preliminarily enjoined that effective date. As of March 2024, the court's injunction remains in effect pending a final determination in the case. The Attorney General of Montana has appealed the preliminary injunction to the U.S. Court of Appeals for the Ninth Circuit. If Montana Senate Bill 419 were to take effect, TikTok and mobile app stores could be fined each time a user in Montana accesses TikTok or is offered the ability to access or download TikTok. The law would become void if TikTok were sold to a company that was not, at the time of the sale, incorporated in a country, quote, designated as a foreign adversary in Volume 15 of the Code of Federal Regulations, Section 7.4, end quote. Have TikTok or other entities challenged any state actions to regulate TikTok in court? TikTok and a group of TikTok users each challenged Montana State Bill 419, Montana's ban on TikTok operating within the state. The challengers asked a federal district court to invalidate and enjoin Montana State Bill 419 on multiple grounds. They argued that the law was preempted by several federal statutes, that it regulated aspects of national security and foreign affairs that are reserved to the federal government, and that it violated the Constitution's First Amendment, the Commerce Clause, the Bill of Attainder Clause, and the 14th Amendment's Due Process Clause. The court, finding that TikTok and its users were likely to succeed on some of these arguments, granted a request to preliminarily enjoin the law from taking effect while the litigation proceeds. In the court's view, Montana State Bill 419 likely violates the First Amendment and the Commerce Clause, and it is likely preempted under the Foreign Affairs Field Preemption Doctrine and by Section 721 of the Defense Production Act. The Attorney General of Montana has appealed the ruling to the U.S. Court of Appeals for the Ninth Circuit. In addition, an organization of academics, journalists, researchers, and scientists filed a lawsuit challenging Texas's prohibition against using TikTok on government-issued devices. The organization argued that the ban, as applied to faculty at public universities, violated its members' First Amendment rights. In this case, the court disagreed with the challengers' arguments. The court held that because Texas's ban reached only, quote, state-owned and managed devices, end quote, the regulation was subject to a lower level of First Amendment scrutiny, which it satisfied. Footnote: the court held that Texas's ban was a, quote, restriction on a non-public forum, end quote. End footnote. The court dismissed the case. Are foreign governments regulating TikTok? The European Union has undertaken regulation of TikTok as part of its effort to regulate the digital economy, and some countries have restricted, blocked, or banned the app. Countries have banned TikTok on government devices, such as Australia, Canada, the United Kingdom, or temporarily blocked or banned TikTok due to concerns about content, such as Indonesia, or during times of political unrest, such as Pakistan. Some countries have banned the app outright, including India, which banned TikTok in 2020 and currently has a ban on 509 apps developed in China. Nepal, Afghanistan, and Somalia have also banned TikTok due to concerns about the content being posted on the platform. End of Section 7, read by Ilse Selwyn. Section 8 of TikTok, Collected Reports by Various. This LibriVox recording is in the public domain. TikTok, Frequently Asked Questions and Issues for Congress by Michael D. Sutherland, Peter J. Benson, and Christian E. Bush. Released April 9, 2024, Part 3. Implications of a Potential Ban or Divestiture of TikTok. How might a divestiture of TikTok work? Some options ByteDance might consider if it chooses to divest TikTok could include the following. Some of the investors of ByteDance might create a new company to operate TikTok. ByteDance might sell TikTok to a third party, such as a group of investors or a company. The People's Republic of China government might not allow either of these options to occur. Under House Bill 7521, as passed by the House, these two options would need to meet the requirements of a, quote, qualified divestiture, end quote, which requires that the app not be controlled by and have no operational relationship with a foreign adversary. Are there potential buyers for TikTok if it was for sale? The parties interested in purchasing TikTok would likely depend on the sales price and the components of TikTok that would be included in the sale. ByteDance might sell TikTok for billions of dollars, which would likely limit the potential buyers. TikTok has a large number of U.S. users and has been expanding the services offered to U.S. users on the app. The amount a buyer is willing to pay might be lower if, for example, the sale of TikTok does not include its algorithms or the data it has collected on its U.S. and other users. Although ByteDance was reportedly valued at $268 billion in December 2023, The current value of the US portion of TikTok is unknown. Some investors reportedly estimate that TikTok has been operating at a loss. Other factors might also limit the potential buyers of TikTok. For example, proposals to purchase TikTok from large technology companies, such as Apple, Google, and Meta, might raise antitrust concerns. After the House passed House Bill 7521, several individuals and companies reportedly expressed interest in purchasing TikTok. Footnote: for example, parties that have expressed interest in purchasing TikTok include former Treasury Secretary Steven Mnuchin, Bobby Kotick, former CEO of Activision, a video game publisher, Kevin O'Leary, an investor in the television show Shark Tank, and Rumble, an online video platform. End footnote. How would a prohibition on entities facilitating the provision or the sale of TikTok affect other social media platforms? If entities were prohibited from facilitating the provision of TikTok to U.S. users, some U.S. users might start to use or spend more time on other social media platforms. In particular, U.S. users might increase use of social media platforms that offer short-form videos similar to TikTok, such as Meta's Instagram Reels and Google's YouTube Shorts, as well as other social media platforms such as Snapchat, X, formerly Twitter, or Reddit. A ban might also provide the opportunity for new social media platforms to emerge to serve the U.S. market, although a new platform might face difficulty competing with existing social media platforms. Footnote: for example, social media platforms benefit from network effects, where the perceived value of an online platform as the number of active users grows, which can make it difficult for a nascent platform to compete with incumbents. End footnote. If TikTok were sold, the effect on other social media platforms would depend on the actions taken by the entity that purchased TikTok. For example, if the entity were to stop offering certain services, or implements changes that some users do not like, the users might start using or spending more time on other social media platforms. Alternatively, if the entity were to make improvements to TikTok, individuals might spend more time on TikTok and less time on or stop using other social media platforms. Which online service providers would be affected by prohibiting the distribution, maintenance, or updating of TikTok in the United States? Section 2 of House Bill 7521, as passed by the House, would prohibit any entity from distributing, maintaining, or updating, or enabling these services of TikTok or foreign adversary-controlled applications, quote, within the land or maritime borders of the United States, end quote, starting 180 days after the enactment of the law. Any entity that violates Section 2 would be subject to a civil penalty in an amount to be determined by the number of U.S. users that, quote, have accessed, maintained, or updated, end quote, the TikTok or covered application using services provided by that entity. The Attorney General would, quote, conduct investigations related to potential violations and pursue enforcement against determined violations. While the bill does not define entity under Section 2, the term could include at least the following two types of online service providers. An online marketplace that allows Internet users to find, download, install, or update a software application. The example provided in the bill is, quote, a online mobile application store, end quote. In the United States, the TikTok mobile app is mostly distributed through app stores operated by major mobile platform developers such as Apple Incorporated, accessible through its iOS platform, and Google LLC through its Android platform. TikTok is also available through third-party app stores, including those operated by Amazon.com Incorporated and Samsung Electronics Company Limited. To comply with Section 2 of the bill, these app stores would either have to remove TikTok from its offerings or make the app unavailable to U.S. users. An internet hosting service vendor that provides data storage and computing resources, quote, for the accommodation and maintenance, end quote, of TikTok's content and resources. The bill includes hosting services such as, quote, file hosting, domain name server hosting, cloud hosting, and virtual private server hosting, end quote. According to a network traffic analysis, TikTok may have used hosting service provided by at least 10 vendors. including US-based cloud service providers Amazon Web Services, AWS, Google Cloud Platform, and Oracle Cloud. In September 2020, the Oracle Corporation announced that it had become TikTok's, quote, secure cloud technology provider, end quote, to deploy, scale, and operate TikTok systems in the Oracle Cloud. TikTok claims that it has, quote, created a standalone version of the TikTok platform for the United States that is isolated inside servers in Oracle's US cloud environment, but can communicate with the global TikTok service in controlled and monitored ways, end quote. To comply with Section 2 of the bill, an internet hosting service vendor would have to either stop hosting TikTok's content and services or disable, quote, the distribution, maintenance, or updating of, end quote, TikTok for US users. Additionally, upon request, quote, the entity that owns or controls, end quote, TikTok would be required to provide, quote, all the available data related to, end quote, a US user's account, including posts, photos, and videos, to the requesting user before the user lost access to the app. Such data would be intended to enable the user to transfer the content to, quote, alternative applications, end quote. Would US users still be able to access TikTok content under the current language in House Bill 7521, prohibiting the distribution, maintenance, or updating of TikTok in the United States? House Bill 7521, as passed by the House, does not specifically address the topic of users within the land or maritime borders of the United States, or US citizens outside those borders accessing TikTok content or using its services after potential enactment of the bill. It also does not address users within the United States bypassing geographic restrictions to access non-US instances of TikTok. For example, a user physically located in the United States could potentially access non-US instances of TikTok or app stores by appearing to be located outside the United States using a virtual private network, VPN, or other services that allow Internet Protocol IP address masking. Footnote: a VPN, or virtual private network, is a virtual network built on top of existing networks that can provide a secure communications mechanism for data and Internet Protocol information transmitted between networks. End footnote. What First Amendment considerations might be raised by government regulation of TikTok? Laws regulating a medium of expression, such as a newspaper or other platform for speech, can trigger First Amendment scrutiny, meaning that if subject to a legal challenge, a court might review the law for compliance with the First Amendment. Federal and state restrictions on TikTok have been subject to legal challenges alleging their restrictions violate the First Amendment's free speech clause. One trial court held a Montana restriction on TikTok was likely unconstitutional, as discussed above. Another trial court similarly issued a preliminary ruling on First Amendment grounds, preventing the federal government from enforcing an executive order restricting transactions related to WeChat. One relevant issue in a First Amendment challenge is the type of free speech interest being asserted. While foreign corporations outside of a U.S. territory may not be able to claim First Amendment protections, separately incorporated organizations within the United States may raise First Amendment claims. In prior legal challenges, both TikTok and the platform's U.S. users have asserted First Amendment claims. U.S. users may have an interest both in receiving speech from abroad, as well as in purely domestic exchanges. Generally, if a law burdens expressive activity, the level of constitutional scrutiny that a court applies depends in large part on the type of expression being regulated and how the law operates. Laws that regulate speech based on its content usually trigger an analysis known as strict scrutiny, under which a law is presumptively unconstitutional and valid only if it is the least restrictive means to serve a compelling government interest. Thus, if a law targeted TikTok or other speech platforms because of the speech they host, or targets certain speech on those platforms, it could trigger strict scrutiny and would be more likely to be held unconstitutional. In contrast, if a law did not target TikTok or another platform because of its speech and did not otherwise discriminate between particular viewpoints or types of content, it might be subject to review under intermediate scrutiny. Intermediate scrutiny requires the government to show the law advances a, quote, important or substantial, end quote, government interest unrelated to the suppression of speech and is, quote, no greater than is essential, end quote, to further this interest. Under some formulations of intermediate scrutiny, the government must also show that the law leaves open, quote, ample alternative channels for communication of the information, end quote. Intermediate scrutiny is easier to satisfy than strict scrutiny, but is still relatively robust. The trial court rulings referenced above concluded that the federal and state governments had likely failed to satisfy intermediate scrutiny. How might the Bill of Attainder Clause apply to legislation that names TikTok? Article 1, Section 9, Clause 3 of the Constitution prohibits Congress from enacting bills of attainder, legislation that imposes punishment on an identifiable person or group without trial. Because some recent legislative proposals identify TikTok or ByteDance by name, questions have arisen as to whether such proposals may be unconstitutional bills of attainder. Courts analyzing bill of attainder challenges consider three questions. First, does the challenged bill apply with specificity? Second, does it impose punishment? Third, does it do so without a judicial trial? If all three factors are met, a court must strike down the legislation as a bill of attainder. With respect to the first question, if a bill applies to a named individual or entity, courts are likely to hold that the specificity requirement is satisfied. Historical bill of attainder cases involved legislation that targeted individuals or identifiable groups of people. Although the Supreme Court has not considered whether the Bill of Attainder Clause also protects corporations such as TikTok and ByteDance, federal appeals courts considering Bill of Attainder challenges brought by corporations have either held that the clause protects corporations or assumed that it does. Identifying TikTok or ByteDance by name in legislation may meet the specificity requirement. The second question, whether a bill imposes punishment, is the most complex. Courts apply three tests for assessing whether a law imposes punishment, known as the historical, functional, and motivational tests. The historical test deems the law to be punitive if it is one of a limited set of legislative actions that were held to be bills of attainder from before the founding of the United States through the mid-20th century, including banishment, imprisonment, confiscation of property, or employment bans. The functional test is generally given the most weight of the three tests and considers, quote, whether the law under challenge, viewed in terms of the type and severity of burdens imposed, reasonably can be said to further non-punitive legislative purposes, end quote. The third test for punishment considers whether the legislature that enacted a challenged law was motivated by an intent to punish the targeted entity. The question of whether a bill imposes punishment is highly fact-dependent. A court reviewing legislation naming TikTok would assess the provisions aimed at TikTok under these three tests to determine whether the law was punishing TikTok. As a general matter, review of whether legislation is punitive for purposes of the Bill of Attainder Clause is deferential, and federal courts rarely strike down laws as bills of attainder. With respect to the third question, if a bill provides for judicial trial before imposing sanctions, it falls outside the prohibition on bills of attainder. Thus, a bill that imposed legal consequences on TikTok or another entity only after a trial likely would not be struck down as a bill of attainder. Footnote: some federal appeals courts have held or assumed that the Bill of Attainder Clause does not apply to actions of the executive branch. The Supreme Court has not considered this question, and the facts and prior cases differ from agency enforcement against TikTok that might be authorized under existing legislative proposals. However, the limited available authority suggests that legislation imposing legal consequences only after discretionary agency action may not be struck down as a bill of attainder. End footnote. What takings clause considerations might be raised by future legislation that regulates TikTok? The Fifth Amendment's takings clause prohibits the United States from taking private property without just compensation. The takings clause's protections apply to U.S. persons and to foreign individuals and entities with substantial connections to the United States, including those whose property in the United States is taken by the federal government. The Supreme Court has distinguished between two types of takings: physical takings and regulatory takings. Physical takings are the paradigmatic example of a taking and occur when the government directly appropriates or physically invades private property. Regulatory takings involve a government acting in its regulatory capacity and are typically analyzed under the framework created by the Supreme Court and Penn Central Transportation Company v. New York City. Under the Penn Central framework, courts consider the following three factors to determine if there is a regulatory taking. 1. Quote, the economic impact of the regulation on the claimant, end quote. 2. Quote, the extent to which the regulation has interfered with distinct investment-backed expectations, end quote. And 3. Quote, the character of the government action, end quote, such as whether it is akin to a physical invasion or whether it is, quote, adjusting the benefits and burdens of economic life to promote the common good, end quote. TikTok might challenge future legislation as a violation of the Takings Clause if it believes the law's restrictions have a severe economic impact on its business and interferes with its investors' expectations. Footnote. In 2020, ByteDance and TikTok raised arguments under the Takings Clause in a challenge to a presidential order that had been issued under the Committee on Foreign Investment in the United States authorities. Those arguments have not been ruled on in court. Such a challenge would likely be analyzed under the Penn Central factors. This analysis is inherently fact-specific and could depend, for example, on the extent of the legislation's economic impact and the reasonableness of ByteDance's expectations when it invested in Musical.ly. As a general matter, any national security arguments invoked by the government could make it difficult for a Takings Clause challenge to succeed. Courts have observed that national security is a paramount governmental interest, and courts have said that valid regulatory actions serving substantial national security interests weigh against a determination that a compensable taking has occurred. What due process considerations might be raised by government regulation of TikTok? Under the Fifth Amendment's Due Process Clause, the federal government may not deprive any person of a protected property interest unless it provides them with notice of the deprivation and an opportunity to be heard before a neutral party. As with the Taking Clause, the Due Process Clause's protections apply to U.S. persons and to foreign persons or entities that have, quote, developed substantial connections, end quote, with the United States through presence or property. The Due Process Clause is primarily applied to actions taken by the executive branch. For legislative determinations, the Supreme Court has said that the legislative process may provide, quote, all the process that is due, end quote, unless the law is, quote, palpably arbitrary, end quote. Beyond the core requirement of notice and an opportunity for a hearing, the Due Process Clause's procedural requirements are flexible and may vary depending on the particular situation. To determine what procedures are required in any given case, courts apply a three-factor balancing test that the Supreme Court articulated in Matthews v. Eldridge. Under this test, the reviewing court must weigh 1. The private interests affected by the determination, 2. The risk of erroneous deprivation of such interests through the procedures the government used and the probable value, if any, of additional or substitute procedures, and 3. The government's interest at stake. The application of this test can lead to different requirements in different circumstances. For example, the U.S. Court of Appeals for the D.C. Circuit has held that, before the president can order a company to divest an acquisition under the Committee on Foreign Investment in the United States process, the government must first provide the affected company with notice of the determination and an opportunity to rebut the evidence supporting it. On the other hand, when the government has added persons to sanctions lists without prior notice, courts have concluded that the government's interest in preventing asset flight outweighs litigants' need for a pre-deprivation hearing. Courts have found it problematic when a party is unable to examine and challenge the evidence on which a determination is based. However, when a determination is based on classified information, courts have recognized that forcing the executive branch to disclose such information would, quote, compel a breach in the security which that branch is charged to protect, end quote. In some cases, courts have deemed it sufficient for the government to provide unclassified summaries of the evidence or have required the government to submit the classified information in camera for the court's review, i.e., permitting only the court to view it. Should Congress consider potential TikTok-related legislation, due process clause analysis would be particularly relevant if the legislation provided for executive branch determinations. To comply with the due process clause, any executive branch decision implicating TikTok or ByteDance's property rights would likely need to provide, at a minimum, notice of the determination, ability to examine any unclassified evidence on which the decision was based, and an opportunity to rebut that evidence. What is Project Texas? Formally announced by TikTok in January 2023, Project Texas is a program currently being implemented by TikTok to address what it claims are the key national security concerns expressed by the U.S. government during the company's negotiations with the U.S. Department of Justice following the 2019 Committee on Foreign Investment in the United States investigation. The Department of Justice and the Committee on Foreign Investment in the United States have declined to comment on the U.S. government's view of Project Texas, citing confidentiality obligations. The core element of Project Texas, according to TikTok, is a localization of all data generated by U.S. users and monitoring of cross-border data flows by a team based in the United States. TikTok plans to do this through the establishment of a new subsidiary, TikTok U.S. Data Security, USDS, based in the United States, which would be monitored by Oracle. TikTok U.S. Data Security would also manage the migration of all TikTok data traffic to Oracle Cloud, and according to TikTok, would establish a dedicated, quote, transparency center, end quote, to allow Oracle employees to inspect TikTok's source code. As of August 2023, media reporting indicates that access to TikTok's source code is a point of contention between Oracle and TikTok employees, and that TikTok is imposing access restrictions and surveillance requirements on Oracle employees that impedes their ability to implement Project Texas. Several experts and members of Congress contend that even if Project Texas was to be fully implemented, it does not address the core problem of ByteDance employee access to user data, which some experts argue could be maintained despite a localization of data in the United States, depending on how ByteDance and TikTok structure internal data security protocols and access permissions. Could a ban, divestiture, sale, or other efforts to regulate TikTok have broader policy implications for digital trade? Until 2023, the United States promoted the free flow of data across borders and opposed data localization requirements in its free trade agreements. Footnote: data localization policies require that data generated within a country be stored and processed on servers within that country. End footnote. These policies were included as negotiating objectives in trade agreements beginning with the passage of the most recent Trade Promotion Authority in 2015, TPA 2015, Public Law 114-26. In fall 2023, the Office of the United States Trade Representative, USTR, withdrew its support for proposals at the World Trade Organization, WTO, that supported open cross-border data flows and opposed data localization. The Office of the United States Trade Representative also suspended digital trade talks in the Indo-Pacific Economic Framework for Prosperity. The Office of the United States Trade Representative, Catherine Tai, attributed the decision to the need for domestic policy space on digital economy issues, given rapid technological advancement and shifting domestic conversations on regulation of the technology sector. Data security. Both Congress and the Biden administration are considering restricting cross-border data flows or supporting data localization in instances when national security or the security of sensitive data on U.S. citizens is at risk. A February 2024 executive order by the Biden administration aims to restrict access to Americans' personal data and American government-related data when access poses a, quote, unacceptable national security risk, end quote, by prohibiting and restricting certain transactions with foreign adversaries, including China. Recent proposed legislation also aims to prevent access to Americans' personal data by foreign adversaries by restricting the activities of data brokers including the Protecting Americans' Data from Foreign Adversaries Act, House Bill 7520, and the Protecting Military Service Members Data Act of 2023, House Bill 6573. Data localization. A component of TikTok's Project Texas is the storage of U.S. user data and servers in Oracle's U.S. cloud environment, with access to that data controlled by TikTok U.S. Data Security, which would be overseen by an independent board. This component of Project Texas, if mandated by the Committee on Foreign Investment in the United States or another U.S. government entity, would be an example of an attempted data localization requirement. Digital trade policy. The Office of the United States Trade Representative has not announced new digital trade policy goals for future discussions with other countries, or put forth new proposals at the World Trade Organization. U.S. trade partners, industry, and other interests could regard U.S. action on TikTok as a signal of the future direction of U.S. digital trade policy. End of Section 8, read by Elsie Selwyn. Section 9 of TikTok, Collected Reports by Various. This LibriVox recording is in the public domain. TikTok, Proposed Legislation and Implications by Kristen E. Bush, Michael D. Sutherland, Claire E. Cho, and Ling Zhu. Released April 23, 2024. On March 13, 2024, the House of Representatives passed the Protecting Americans from Foreign Adversary-Controlled Applications Act, House Bill 7521. This bill would make it unlawful for any entity, quote, to distribute, maintain, or update, end quote, a, quote, foreign adversary-controlled application, end quote, hereinafter referred to as a covered app, within U.S. jurisdiction, unless a, quote, qualified divestiture, end quote, occurs. The bill specifically identifies those operated by ByteDance Limited and TikTok as foreign-controlled applications. On April 20, 2024, the House passed an amended version of House Bill 7521 as Division D of House Bill 8038, the 21st Century Peace Through Strength Act, which is discussed in below sections. Background on TikTok. The People's Republic of China, PRC, government holds an equity stake and board seat in the entity that conducts ByteDance's core business in China, Beijing ByteDance Technology. Due to this, TikTok has faced scrutiny from policymakers for potential privacy and national security risks. Critics allege the People's Republic of China influences ByteDance's content policy or may compel it to turn over user data in accordance with the People's Republic of China laws that codify the government's ability to compel data access and require data localization in China. Shou Chu, Chief Executive Officer, TikTok Incorporated, has denied these allegations in his March 23, 2023 testimony before the U.S. House Committee on Energy and Commerce. TikTok is banned on federal executive agency devices under the Consolidated Appropriations Act, 2023, Public Law 117-328. Many states have banned the app on some or all state-owned devices. In May 2023, Montana passed a statewide ban on TikTok, but the ban was blocked by a district court in November 2023. First Amendment and other legal issues associated with a forced divestiture or ban of TikTok and similar platforms are discussed in other Congressional Research Service products. Overview of Division D of House Bill 8038. Forced divestiture. Division D of House Bill 8038 would subject any entity that distributes, maintains, or updates a covered app to civil penalties unless a, quote, qualifying divestiture, end quote, takes place within 270 days of the bill's enactment. It had been 180 days in House Bill 7521, and added the ability for the President to grant a one-time extension of 90 days if certain requirements are met. For TikTok to continue to operate within U.S. jurisdiction through divestiture, ByteDance would likely need to sell its U.S. operating subsidiaries to an entity that is outside the People's Republic of China jurisdiction. People's Republic of China officials have stated the People's Republic of China government would oppose a forced sale of TikTok, with China's Ministry of Foreign Affairs asserting on March 13, 2024, that legislative proposals that would prohibit a, quote, foreign adversary-controlled application, end quote, from operating in the United States use national security as a pretext, quote, to willfully suppress other countries' superior companies, end quote. Several analysts observe that such comments are at odds with the People's Republic of China government's own policies that prohibit U.S. and other foreign social media companies from operating in China. The People's Republic of China government could leverage a wide range of tools, including export controls. Social media algorithms are a controlled technology under China's export control law. Its equity stake in ByteDance's China operations, or China's data security law to exert pressure on ByteDance to avoid a sale. A divestiture consideration may be who would be willing and able to purchase the platform. TikTok would likely be sold at a high price given its large number of users and potential for future growth and revenue. ByteDance was reportedly valued at $268 billion in a company share buyback in December 2023. However, the value of the US version of TikTok is uncertain. A high selling price may limit the entities that are able to purchase TikTok. Some large technology companies, such as Apple, Google, and Meta, might be able to purchase TikTok, although any proposals to do so might raise antitrust concerns. Technical requirements and uncertainties of U.S. ban. Section 2 of Division D of House Bill 8038 creates technical requirements for several types of online service providers. Violations could lead to civil penalties as enforced by the Attorney General. 1. Entities distributing software apps through an online marketplace. For example, a mobile app store operated by Apple Incorporated or Google LLC would need to remove the covered app or inhibit U.S. users from finding, downloading, installing, or updating the app. 2. Entities hosting the covered app. For example, a cloud computing provider or a content delivery network (CDN) provider would need to stop hosting or delivering the covered app's content or inhibit U.S. users from accessing the app's content and services. 3. Entities that own or control the covered app. For example, TikTok Limited would be required to provide, quote, all the available data related to, end quote, a U.S. user's account, including posts, photos, and videos, to the requesting user before the user loses access to the app. Such data is intended to enable the user to transfer the content to, quote, alternative applications, end quote. Division D of House Bill 8038 does not address the implications of U.S. users accessing a covered app through various services that may bypass geographic restrictions. For example, if a user physically located in the United States uses an IP address masking technology, such as a virtual private network, to access a covered app by appearing to be located outside of the United States, or through services outside the United States, it is unclear what entities, if any, can be held liable for app distribution. Additionally, if individuals request their user data from a covered app operator, some might not have sufficient equipment to handle and secure the requested information, which may create privacy or data security risks if the released data contains personally identifiable information. Users in competition. The effect of Division D of House Bill 8038 on users in competition would depend on a covered company's response. If a company chooses to pursue a divestiture, it might not affect users or competition. The effects would depend on the purchasing entity. For example, if the purchasing entity operates an app similar to the divested app, it could reduce competition. The purchasing entity could also stop offering certain services affecting users. If a company chooses not to divest its app, prohibiting the app from providing U.S. services might have a financial effect on U.S. businesses that use the platform to advertise products, and individuals who are paid to sponsor products because they have a large number of followers, i.e., influencers. Prohibiting the app from providing services might also reduce competition depending on the app's market share. TikTok estimates that there are 7 million U.S. businesses and 170 million active U.S. users on its platform. Some influencers are reportedly lobbying Congress to reject Division D of House Bill 8038. Some TikTok users might switch to other social media platforms, particularly those that offer short-form videos similar to TikTok, such as Meta's Instagram Reels and Google's YouTube Shorts, potentially increasing their respective market shares. End of Section 9, read by Elsie Selwyn. Section 10 of TikTok, Collected Reports by Various. This LibriVox recording is in the public domain. TikTok and China's Digital Platforms, Issues for Congress, by Karen M. Sutter and Michael D. Sutherland, released April 25, 2024. Congress and U.S. policymakers at the federal and state levels have taken steps to address their national security-related concerns about the People's Republic of China's influence over People's Republic of China-tied digital platforms operating in the United States. Most U.S. actions to date have focused on TikTok, owned by ByteDance, a company with ties to the People's Republic of China government. Other expressed concerns include People's Republic of China platforms' large user bases, access to large amounts of U.S. data, and company data and content policies. TikTok has an estimated 148.9 million U.S. users as of January 2024. TikTok's CEO testified to Congress in March 2023 that ByteDance retains in the People's Republic of China at least 7 years of U.S. TikTok users' data. Enacted in April 2024, Public Law 118-50 has provisions that address the People's Republic of China digital platforms and related data issues. Division H requires ByteDance to divest TikTok and allows the president to address other People's Republic of China-controlled digital platforms. Division I prohibits the transfer of U.S. personally identifiable sensitive data to foreign adversaries, including the People's Republic of China. People's Republic of China digital firms are able to serve the U.S. and the People's Republic of China digital markets, while U.S. firms remain restricted in China. This asymmetry raises other potential issues for Congress, such as market access reciprocity, fair competition, and U.S. regulation of People's Republic of China digital firms. China's digital platforms have expanded in the U.S. market over the past 10 years. See Table 1. Many firms have entered otherwise regulated or restricted parts of the U.S. government, broadcasting, media, health, and financial services, through mobile applications, apps. People's Republic of China restrictions on foreign firms and investment in related technology sectors inhibit the ability of U.S. digital platforms to operate in China. Digital platforms are internet-connected and software-based digital spaces that facilitate the exchange of goods, services, and information, and the creation of value through online interactions of businesses and individuals. China's digital platform development. People's Republic of China policies prioritize the role digital platforms play in China's economic competitiveness, the development of emerging technologies, and People's Republic of China global projects in sectors such as communications, smart cities, financial and logistics services. China's digital platforms emerged in the late 1990s with the help of People's Republic of China government policies that restricted U.S. internet services firms from operating in China while promoting alternative People's Republic of China competitors. Alibaba began in 1999 as a competitor to Amazon and formed Alipay in 2003 to compete with PayPal. Baidu started as a Google competitor in mapping and search engines. Sina Weibo began as a challenger to Twitter. Tencent's WeChat competed with WhatsApp. In 2016, ByteDance refined the algorithm for its news aggregator business, Toutiao, to launch Douyin, a predecessor-turned-companion People's Republic of China application to TikTok, a service that competed with Facebook and YouTube. The People's Republic of China universe of digital firms has expanded as industry more broadly has adopted digital services, and now includes other firms such as BGI Biotech and DJI Drones. As People's Republic of China digital firms become viable in China, some moved into global markets. The People's Republic of China government loosened capital restrictions and allowed some People's Republic of China firms to list and expand overseas. In 2014, Alibaba raised $21.8 billion in its offering on the New York Stock Exchange. U.S. investors in TikTok's People's Republic of China parent, ByteDance, include Sequoia Capital, Susquehanna Group, and KKR. Some People's Republic of China firms initially focused on app offerings to enter foreign markets. In this approach, People's Republic of China firms used existing foreign operating systems on mobile phones, such as Apple's iOS and Google's Android, to avoid upfront technology infrastructure costs and expand quickly. Once established, some People's Republic of China firms developed their own infrastructure, such as cloud services, data storage, and semiconductor design. People's Republic of China firm Huawei is developing its own operating system. In other approaches, some People's Republic of China firms inherited foreign user bases and licenses through acquisitions. This approach gave some firms, such as ByteDance, a significant initial U.S. market position and accelerated these firms' expansion. In 2017, ByteDance acquired Musical.ly, a short-form video app firm. The deal gave ByteDance 80 million monthly U.S. users, a base that is more than half of TikTok's current user base. ByteDance then used that U.S. user base in launching TikTok. In another example, People's Republic of China firm Tencent invested in Blizzard Entertainment, Snap, Snapchat, Riot Games, and Epic Games, the owner of Fortnite, a large gaming and online marketplace platform. Table 1. Key People's Republic of China digital platforms in the U.S. market. People's Republic of China firm, ByteDance. U.S. business, TikTok. Sectors, social media. People's Republic of China firm, Tencent. U.S. business. WeChat. Sector, super app. People's Republic of China firm, Tencent. U.S. business, Snap/Snapchat. Sector, social media. People's Republic of China firm, Tencent. U.S. businesses, Blizzard, Riot, Epic. Sector, gaming. People's Republic of China firm, Alibaba. U.S. businesses, Alibaba, Alipay. Sector, e-commerce/payments. People's Republic of China firm, Baidu. U.S. business, Apollo. Sectors, mapping, autonomy. People's Republic of China firm, Yidian Yishun. U.S. business, Newsbreak. Sectors, news, media. People's Republic of China firm, Temu. U.S. business, Temu. Sectors, e-commerce, clothing. People's Republic of China firm, Shein. U.S. business, Shein. Sectors, e-commerce, clothing. People's Republic of China firm, Zoom. U.S. business, Zoom. Zoom.gov. Sector, business software. People's Republic of China firm, Shiji Tech. U.S. business, Shiji Technology. Sectors, business software/hotel. People's Republic of China firm, Binance. U.S. business, Binance.us. Sector, crypto. People's Republic of China influence and control. Since 2014, the People's Republic of China and the Communist Party of China, CPC, have adopted interrelated laws, economic security measures, and data restrictions that enhance their control over data and commercial activity within and outside China. They have expanded data localization requirements and placed controls on the export of data and algorithms. In 2021, they introduced security review requirements for People's Republic of China firms listing or operating overseas. These provisions require firms to adhere to People's Republic of China rules when they conflict with U.S. laws. People's Republic of China measures seems to be more extensive than other countries' approaches to data security. Such measures have affected U.S. firms' operations in China, raising questions about the extent to which People's Republic of China-tied firms operating offshore are independent of the People's Republic of China government. Examples of People's Republic of China authorities include China's National Security Law, 2015, requires information systems in China to be, quote, secure and controllable, end quote. The law underpins requirements that U.S. firms store data and cryptographic keys in China. The People's Republic of China's National Cybersecurity Law 2017 requires firms to store personal information and data within China. The law builds on related requirements to place People's Republic of China data and related infrastructure in China. China's Data Security Law 2021 covers data processing inside and outside China if it, quote, harms the national security, public interest, or the legitimate rights and interests of citizens or organizations of the People's Republic of China, end quote. The law requires People's Republic of China government approval for the transfer of data stored in China. It calls for classifying data according to its importance to China's economic development and national security interests. In August 2020, the People's Republic of China government placed export controls on algorithms used in social media platforms. Some experts saw this as an effort to influence TikTok and other People's Republic of China digital firms' offshore operations. The Communist Party of China requires all firms to host a party committee that is empowered to attend board meetings and be part of decision-making. The People's Republic of China government is also an indirect shareholder in some firms. For example, it holds a board seat in Douyin Information Services Company Limited, the owner of TikTok's core technology, via a 1% shareholding by a firm backed by China's internet regulator. Other People's Republic of China tools to influence People's Republic of China digital platform firms include People's Republic of China official content guidelines and censorship rules, restrict and promote content on People's Republic of China digital platforms. China's anti-espionage, cybersecurity, and data security laws compel firms to support People's Republic of China state security authorities. The core business, such as software and technology development, and intellectual property is based in China, owned by a People's Republic of China parent or subsidiary, and subject to People's Republic of China jurisdiction. Offshore structures, such as global headquarters, can obfuscate ties to this underlying People's Republic of China business. Issues before Congress. The executive branch has taken steps to restrict some People's Republic of China digital firms' operations. Public Law 118-50 designates TikTok as a, quote, foreign adversary-controlled application, end quote, and requires ByteDance to sell TikTok to a non-People's Republic of China owner. It focuses on specific People's Republic of China-related national security concerns and conduct of the platform, and allows TikTok to operate under new ownership. Proponents have said that this approach was designed to withstand a potential court challenge and respond to congressional deliberations that highlighted a need to address national security risks, while allowing TikTok a path to continue to operate in the U.S. market. The provisions incorporated requests from some senators to allow up to 1 year for any divestiture. Members debated how much discretion to give the president to make determinations, and whether Congress should protect U.S. data and oversee digital firms more broadly. In response, Public Law 118-50 allows the president to restrict other foreign adversary-controlled apps, including People's Republic of China-tied digital platforms, and prohibits the transfer of U.S. personally identifiable sensitive data to a foreign adversary country or an entity controlled by a foreign adversary, including the People's Republic of China. The Federal Trade Commission is to enforce the data provision. Key U.S. government actions. The U.S. government has taken the following actions to restrict some operations of certain People's Republic of China digital firms. May 2019, Executive Order 13,873 declared a national emergency to secure U.S. information and communications technology and services supply chains. The executive order has been renewed annually since 2019. It is up for renewal in May 2024. January 2020 to present. Some federal agencies and state governments banned the TikTok app on government devices. March 2020. A presidential order required People's Republic of China firm Shiji Technology to divest Stay in Touch, a U.S. software provider. It did not ban the firm from operating in the U.S. market. August 2020, a presidential order required ByteDance to divest Musical.ly/TikTok under the Committee on Foreign Investment in the United States, CFIUS, authorities. TikTok is contesting the order in court. Since February 2021, the case has been in abeyance at the request of the parties. August 2020, Executive Order 13,942 and Executive Order 13,943, later rescinded, restricted the U.S. operations of TikTok and WeChat. Court injunctions blocked their implementation. January 2021, Executive Order 13,971 provided for scrutiny of apps and software developed or controlled by People's Republic of China firms. June 2021, Executive Order 14,034 replaced Executive Order 13,942 and Executive Order 13,943. It created a Commerce Department program to address risks of foreign adversary-owned, internet-tied, and software firms. Issues before Congress continued. Public Law 118-50 allows the President to authorize a, quote, qualified divestiture, end quote, of TikTok and impose terms. The August 2020 presidential order that required ByteDance to divest Musical.ly may inform a, quote, qualified divestiture, end quote. In referring the matter to the President, the Committee on Foreign Investment in the United States, quote, unanimously recommended, end quote, such action expressly, quote, to protect U.S. users from exploitation of their personal data, end quote. TikTok tried to reopen a mitigation path that the Committee on Foreign Investment in the United States determined was not viable by legally challenging the order, mostly on due process issues and republicizing mitigation ideas. Some experts say TikTok could store data in the United States and allow government monitoring. Others say such terms would not address ties to technology and functions in China, including regular software updates and continuous data transmission. Congress might A. exercise oversight over any divestiture, B. examine whether TikTok's legal challenge suggests any statutory or policy gaps, and C. consider whether to act with regard to other People's Republic of China platforms. End of Section 10, read by Elsie Selwyn. End of TikTok, Collected Reports, by Various.